always so picky. She always just kind of, I don't know. Give me something better. Okay, I'll eat it. I'll eat it. Well, today is the, let's see, I guess we have closing arguments and the verdict and then all this explanation stuff prior to that. So this one's 3 hours and 56 minutes. So I thought I'd get it started right now. All right. So here we go.
Hope everyone had a nice night. Yes, Mr. Marquise, thank you. Good morning. All right. Let the record reflect everyone is present, including Mr. Summers. Good morning to everyone again. The first thing, well, we're going to get to in just a moment. Mr. Summers, I gave you the evening to consider your decision whether to testify or not testify. We're going to get to that in a moment. And we have some time because one of our jurors, I just want to let you know that number 7 is not here yet. That's the same gentleman that was late yesterday. But it's all right. We'll see. We'll address that. That would be the last thing we address, and maybe he'll be here. The traffic was terrible. It took me twice as long to get here this morning, so I suspect that the traffic is probably the reason for that. But the first thing that I want to address this morning is that I was advised by the clerk's office this morning that for approximately 1 hour last night, the evidence was left in the main clerk's office before it was ultimately moved to the evidence vault. The clerk's office, though, this morning has gone through all of the items of evidence with the list and has verified that all of the admitted evidence is, in fact, accounted for. So I just wanted, since they notified me of that, I wanted to notify you all of that same information. All right? All right? All right. So that takes care of that. The jurors here, which is great. So things are starting to fall into place. So now, Mr. Summers, I am going to turn to you and address you and your decision whether to testify or not. The first question, actually, I do have to swear you in if you'll raise your right hand because I have to ask you a number of questions. Thank you. Do you swear affirm any testimony that you may give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, thank you, sir. The first question that I want to ask you is, did you have the opportunity to consult with standby counsel regarding your decision to testify or not testify in your case?
Yes, Your Honor.
Do you understand that you have the absolute right to remain silent and not testify in your case? The other side of that is, if you wish, you can come down and testify as a witness, just as all the other witnesses have testified. I think I mentioned the procedure to you yesterday. I will follow the same procedure as all the other witnesses. You'll come in front of me. I'll swear you in. You'll take the stand. The only difference is, since you're representing yourself, you won't have someone else to ask you questions, so your testimony will be presented in a narrative form where you can just talk to the jury. If at any time you are presenting testimony that the state believes is objectionable, they would then object, give me the legal basis for the objection, and I would make a decision as to whether you can continue saying that. The issues that may come up are relevance, hearsay, things like that. So much like the things that have come up with other witnesses. At the end of the day, it is your decision and your decision alone whether you are going to testify or not. My next question to you, sir, is have you had sufficient time to consider this very important decision?
Yes, I have, Your Honor.
Have you made a decision?
Yes, Your Honor.
What is your decision?
I will not testify.
Has anyone forced you or threatened you in any way to reach this decision not to testify?
No, Your Honor.
Are you under the influence today of any alcohol, drugs, medication, prescription, or over-the-counter that may in any way affect your ability to freely and voluntarily make this decision?
No, Your Honor.
Okay, thank you. I appreciate it. Let me just see. State, did you have anything else that you want me to ask him regarding his decision?
No, Your Honor.
All right, thank you. Thank you very much, Mr. Summers. So that means that you need to rest your case. Again, I can't help you and I'm not helping you, but some of the procedural things that you may not be aware of in order for us to move forward, I will let you know. That means that you have presented all of the evidence that you intend to present. Do you agree? Is that correct?
Yes, Your Honor.
All right. So that means that we are at the stage where you would rest your case. What I propose that we do, since all of the jurors are here, is that I bring them out. I turn to you, I welcome them, I ask them if they've been exposed to the case, just like I've done every other morning. I then turn to you and ask you, or tell you, you may proceed. And then it would be time to announce the resting of your case. Then once you've done that, I will tell them that there are legal matters, because we then have to go over the jury instructions, the charging conference that I mentioned, and I asked you to read the instructions last night. So I would then explain to them that now that, well, let me just make sure. I would then, once the defense rests, turn to the state, who has the opportunity, if they wish, to request a rebuttal case. Is there any such request?
No, Your Honor.
All right, excellent. So knowing that, what I may do once he rests, I'll turn to the state. Is there anything else from the state? And you can say nothing. And then I'll tell them now both sides have rested their case. I have to go over the legal instructions and legal matters with them. I don't know how long that's going to take, and send them out. I know that now I don't know how long it's going to take, but I know it's not going to be super short. So I'll leave it up to the bailiffs if you want to let them go to the coffee shop or something like that and come back, since they're going to be in that room for a little bit of time. Is there any objection to that procedure?
No.
Just like when they take a lunch or anything like that, we'll tell them maybe an hour. It may not take that long, but I'd rather that we're done and waiting for them than they're back there waiting for us.
That's fine, Your Honor.
Do either of you think that an hour? I mean, I could say let's do 45 minutes. We have to print, so we'll tell them 45 minutes. All right. So they can go for 45 minutes. All right. Is there anything else from the state before I bring them in?
Nothing from the state, Judge.
Mr. Summers, anything from the defense before I bring in the jury?
Not at this time, thank you.
All right. Let's get the jury. Thank you. And I'll try very hard not to say ladies and gentlemen and then correct myself. It's only, the fourth day. Good morning. How are you? It's not as cold in here today.
Not yet. It gets colder though.
It's really cold.
By the afternoon, it's freezing.
I need the paper, so if you can email it to Yes, we are.
All rise during your court.
Jury is present and seated. Everyone else may be seated at this time. Gentlemen of the jury, good morning and welcome back. I know it's a little bit later than we had expected to bring you in. I do apologize for that. Take full responsibility. I also know the traffic was very bad this morning. I'm not responsible for that, but I was actually part of that myself in that traffic. But thank you all for being here and for being here safely. First thing I need to ask you is whether any of you, by raising your hand and letting me know, were exposed to anything about this case outside of the courtroom between the time you left yesterday and the time that you returned this morning. Let the record reflect there are no hands. Additionally, I will ask whether any of you discussed this case amongst yourselves or with anyone else between the time you left yesterday and the time you returned this morning, by show of hands. Let the record reflect there are no hands. Again, thank you all very much. So, you may recall that we left off yesterday in the defense case. I am now going to turn to the defendant and ask him to proceed.
Your Honor, at this time, the defense is yes.
All right. Gentlemen of the jury, is there anything else from the state?
Nothing further from the state, Judge.
All right. Gentlemen of the jury, each side has now concluded their presentation of the evidence in this case. You may recall from the initial instructions that the next phase is the closing arguments of the attorneys, the state, and the defendant. After the closing arguments is the instruction on the law. I cannot finalize or could not finalize the instructions on the law until all of the evidence was admitted. I am going to excuse you, and I am going to finalize the instructions. I'm going to, we're going to take a 45-minute break, and I believe it's my understanding that the bailiff is going to let you go to the coffee shop or anything you want and come back in, and we should be ready at that time and proceed to the closing arguments and the instructions on the law. Please be very careful not to be exposed to anything outside of this courtroom about this case and to not discuss this case amongst yourselves or with anyone else. Again, thank you all very much for your time, your patience, and your service. All rise for the jury. Jury has exited. Everyone may be seated. All right. Both sides have rested. Mr. Summers, is there anything that you want to say or put on the record now that you've rested your case?
Your Honor, would you like to discuss the jury instruction of the abandonment purpose?
That will come. We're going to do a charging conference in just a moment, and yes, we will discuss that during the charging conference. But is there anything else that you want to? And if you want to lean over and talk to Mr. Marchese, I'll allow you to.
I do have a question.
About me. Yes, sir. Pardon me.
Absolutely. I do that. Summers, was there anything else? You said you had a question, and I absolutely will get to that question. If you want to ask that question first, you can do that, or if there's anything else you want to do or say at this time.
I'll wait until we get to the jury instructions for that question.
Okay.
But I would, again, move the court for a verdict of acquittal. Your Honor, the defense moves for a verdict of acquittal for failure of the state to prove a prima facie case against me. On the first and second charge of premeditated attempted first-degree murder, the state has failed to prove any premeditation. And I add abandonment of purpose. The facts clearly show an abandonment of any attempts. The defense moves for a directed verdict of acquittal for failure of the state to prove a prima facie case against me on the charge of kidnapping. The state has failed to prove the purpose of the kidnapping was for grand theft. And the state has failed to prove any intent to commit the crime of grand theft, the alleged purpose for committing the kidnapping. And on the charge of grand theft, the state has failed to prove any intent to commit grand theft. On the two charges of sexual battery by a person 18 or older and upon a victim 18 or older, the state has failed to prove any intent to commit both counts of sexual battery by a person 18 or older upon a victim 18 or older. I thereby move the court for a verdict of acquittal, please.
All right, let me just give the state a brief opportunity to respond to the question.
Judge, as far as to counts 1 and 2, the state has shown a prima facie case of premeditation. We clearly have testimony from Ms. Mathewson, who said, as to count 1, that he came into the bedroom with the pillow, puts the pillow on her, then gets on top of her and proceeds to straddle her, applying more pressure. As far as count 2, testimony was that the defendant went from the front driver's seat to the third row, got behind her while she was tied up, claiming he needed to write a letter to his parents. And at that point, that's when he pulled the rope and was strangling her. There is no abandonment in this case, Judge. Because he failed to carry out the actions in which he intended to do is not abandonment. I have case law prepared, Judge. I'm ready to go ahead and just argue that if you would like.
Yeah, let's wait till we get to the attempt instruction, because that's part of the standard instruction on attempt that includes abandonment. So let's wait till the charging conference to argue that.
Okay. As far as to the grand theft, Your Honor, it is clear from the testimony that after Ms. Mathewson tried to run away at the Walgreens, the defendant ran out of the store, grabbed her, forcefully put her back into the car, and drove away from the Walgreens. There's testimony that for 2 days he was driving around Hillsborough County, Manatee County. That is evidence of him depriving her of her vehicle.
Let me just ask, I apologize for cutting you off, but when you say things that I want clarification on and not sure that I understand, is it your position that the depriving of her was related to the Walgreens and not when they left the house, or that when they left the house, but somehow what happened at Walgreens? I just didn't understand. Go ahead.
Yes, Judge. Starting from the house, because we have testimony that he tied her hands behind her back, puts a blanket around her shoulders, puts her in the back seat or the second row. He's the one who got the car keys. He's the one who drives, and per his own statement with Sergeant Remia, drives to the Walgreens. And then it continued from there. We even have his statement to Sergeant Remia, or what he says to Ms. Mathewson is that we can't go see the kids now because of her trying to run away. And at that point, proceeds to drive around Hillsborough County, down to Manatee County, Anna Maria Island, finally ending up 2 days later in Little Harbor. And the jury instructions as far as a grand theft of a motor vehicle or obtaining or endeavoring to obtain means either permanent or temporary. And in this case, we have 2 dates, Judge.
Okay. What about the other, you want to respond to the kidnapping, but the sex battery?
As far as the kidnapping, the state's relying upon all the testimony provided. There's an independent witness who saw it happen. Lastly, as far as the sexual battery, it's up to the purview of the jury to decide whether there was consent or not.
Right, but specifically, what evidence are you contending is enough to get past this stage and be presented to the jury?
The fact that he snuck into the house in the middle of the night, he wakes her up, her testimony being that he grabs her by the ankles, pulls her off the bed, an argument, struggle ensues in the living room. Ultimately, once the kids are gone, she's tied up in the bedroom. All of those acts that the defendant took carry along with Ms. Mathewson's testimony that the sexual act that took place against her was not consensual.
Okay. Thank you. Mr. Summers, any brief response to anything that the state has presented at this time or argued?
Yes, I continue my standing objection to the statement made in the hospital I do concur that that was something that was not voluntary. And but however, Your Honor, if they're weighing on that, there are other statements I made in that interview where I never said I intended to kill somebody. I never even mentioned strangulation, if they're relying upon that. Nor did I mention desire or intention to steal a vehicle. I speak about it as a common item that we share, that we use. And I also speak about the sexual encounters as casual. It is something that is a common thing between the victim and I at that time and prior to that. And the victim herself stated that sex doesn't mean that much to her.
I mean, that doesn't mean that someone who is of that position can't be sexually battered just because sex doesn't mean that much to her.
I understand, Your Honor. And I'm explaining to you as best I can without testifying as to the situation at the time. But I can just assert that none of my statements have, whether recorded or not, have led to there to be any belief that that I intended to do that out of coercion, out of desire, out of anything other than just something that her and I agreed to do to pass the time. And aside from that, Your Honor, again, the vehicle, there is no evidence of me needing that vehicle, requiring that vehicle. She attested to the fact that when we go out, I drive. And again, Your Honor, I have not attested to these facts, that the only things they're relying on are a statement that I, again, have objected to. And I would also object to their statement that Ms. Summers, or Ms. Mathewson stated that I brought a pillow into the room because I don't believe that was presented in the testimony during this trial. I believe that is a statement she made in a previous recorded proceeding, but not during this trial.
Well, that's ultimately certainly something that you can argue to the jury, and I will instruct the jury that they rely on their own recollection, that what you and what the state says during closing arguments is not evidence, but that they're to rely on their recollection of the testimony. So that's the issue may come up there. But what I want to understand right now is, it appears that your legal position is that you never intended to commit the crime of, I guess, murder, and that you never intended to commit the crime of kidnapping. I mean, that's, I think, what I heard you say. Is that correct?
Correct, yeah. There is no intention from her statements or my statements.
Okay, and that is certainly an argument, a defense that you can raise and argue to the jury. But my question to you, it's about to come up in the instructions, is how can you abandon something that you never intended to do? You see what I'm saying? I mean, do you understand that? If my position is I never intended to touch that book, then how can I argue that I abandoned? What did I abandon if I never intended? You abandon your lack of intent to touch. I never intend to do something. How do you then argue that I abandoned? What are you abandoning if you never intended to do it?
Your Honor, again, I believe that goes to the legal argument, and if you'd like me to cite...
But your legal position in your motion is that I never intended to do it. I just said, it sounds to me like that's what your position is. Is that your position? And you said, yes, it is. I never intended to do it. So, and I said, and we will, I'm going to deny your motion for a judgment of acquittal at this time. But now we're going to move to the jury instructions. And when we get to the abandonment, I'm curious to see what you say, because now you're going to argue that I don't know what you abandoned if you never intended. So,
may I answer that
sure,
question for you?
Yeah, I'd love to hear it.
In my own statement, I never intended to commit murder, or intended to murder her. I never intended to kidnap her. But in addition to that non-intention, I add to that the defense of abandonment, based on her statements that both times she says, I just stopped. And that is where I add in the factor of abandonment of purpose.
So tell me exactly what you're abandoning.
Abandoning the process of attempting to kill someone.
Process of attempting to kill someone when you never had any intention to kill someone. Is that a correct statement?
Yeah, because in the first place, I didn't have the intention. And then the intention is derived by the victim's understanding, not by me admitting it, not by my own desire, not by my own actions. There's a variety of other reasons why things could have happened according to the way she says they happened. They don't have to all lead to the attempt to murder.
It just appears to me, at least at first blush, that those are separate defenses. Didn't intend to do it, so I'm not guilty of it. I intended to do it, but I abandoned my process of doing it. Are separate defenses that are mutually exclusive of each other.
I understand what you're saying, Your Honor. I'm giving you the fact that there is no intention, and there's no proof of my intention. It's only her perceived feeling. There is no proof of that intention.
And you're welcome to argue that to the jury.
Right.
But that's a defense. But then to also be allowed to argue that I abandoned I just don't see how you're going to do that. I never intended to do it. However, I abandoned my attempt to do it.
And again, Your Honor, that's the legal argument that is available to me to bolster
It's not
my...
always available. It's available if there's evidence of it. I tell you what, I understand, absolutely. Let's start with the jury instructions, and then we'll get to that in just a moment.
Okay.
All right, go ahead and have a seat.
Thank you, Your Honor.
Uh-oh. I need my copy. Do you have a copy of the full instructions? Mine's on my desk. Thank you. My staff attorney has the instructions up, and it's just easier if she makes any changes that we discuss, because she can print them directly rather than waiting for an email that sometimes takes forever and then printing them. So we've learned a few things over the years, and it's just quicker if she makes the changes and prints them directly. I will, of course, give you all copies of the printed version so that you can verify that any of the changes that we discussed and agreed upon are in fact made. What's been handed to you was my proposed consolidation of counts 6, 7, and 8 into one instruction on neglect of a child. So just so you know what it is and you can start looking at it, we'll insert it into the stack where it goes, and then I just want to go orderly through each one, and we'll be able to discuss it. But since it was handed to you, I want you to know what it is.
Judge, it needs to include count 9, though.
6, 7, 8, and 9?
Yes.
GS.
Okay.
All right, we'll make that change.
Yeah, well, let's get.
Yeah, I'm not saying I'm giving it. We're going to talk
Yeah,
through
I
it.
was
We're
gonna
going to
say,
talk about it. We may end up doing them all separate. I'm sorry, Mr. Summers. You were standing, so did you want to ask something or say something?
No, same comment.
Okay. Thank you.
Just so you know, this.
Remember, I can pull it. What I instructed them. What's happening now, Mr. Summers, is the formal instructions on the law can either be given before the closing arguments or after the closing arguments. Traditionally, it was always given after the closing arguments. Sometimes attorneys come in and request that it be done prior to. I honestly don't care whether I read all of the substantive instructions on the law before the closing arguments are given or after. I have no preference. But there is an initial instruction in the beginning that tells them how we're going to do it, and that's what I want to go back and look at, what I instructed them.
Your Honor, if you read what was provided by the state, you had stated to the jury.
I have it. Let me read it,
Okay.
because this is the actual instructions that I read from. What I read was, after the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will instruct you on the law applicable to the case. After the final instructions are given, you will then retire to consider your verdict. So I told them that you're going to do closing arguments, and then I'm going to give them the final instructions. Is there any requests now that after I've informed them of that, to proceed otherwise from the state?
I defer the court, Judge.
From the defendant?
I would defend this.
All right, I'm going to do then what I told them I'm going to do in the initial instructions. Thank you all. I appreciate that. And that was the easy answer. I told them one thing, and I hate to change. I'll change as few things as I can about what I told them. Go ahead.
Yeah, we gotta move these now.
So, as if they were going to be given before the closings. So the initial said that they were going to be given after, but there's something in them now, I'm being told, that indicates that they are given before.
Yeah, 3.1 right now says both the defense and state defense have rested their case. Please pay attention to the instructions I'm about to give you. You need to start with closing argument.
All right, so
Just give me 2 seconds.
Yes, Judge. I went off of instructions from Judge Kaiser's courtroom. I know that multiple judges like to do instructions first and then do closings, and I wasn't aware of what Your Honor's preference was, so I had just utilized what we typically do in Judge Kaiser's.
and that's absolutely not a problem. But the problem I have is
I've already fixed it.
that the instructions that were presented, you heard what I read, right?
Yes, Your Honor. I had prepared these last week. Yes.
So,
All right.
So now your first instruction will be 2.7, which is all the way in the back of that packet. So,
2.7. They just stick together for me. There we go. All right, and we put that at the top. So page 60 will actually now become page 14. Mr. Summers, were you able to find that?
Yes.
All right. This is not a big deal at all, but the language is slightly different depending upon whether I do the instructions before you do your closings or after you do your closings. So 2.7, closing argument. It's the introduction to closing argument. Mr. Summers, is there any objection to it?
No.
All right. So next, I would have 3.1, introduction to final instructions,
you will not read the first sentence.
and I'm scratching out the first sentence. And we're fixing that as I speak, unless someone objects. State agree, scratch the first sentence.
Yes, Judge.
Mr. Summers, you understand and agree? I'm going to scratch the first sentence.
Yes, Your Honor.
All right, so then I'm going to read members of the jury. I thank you for your attention during this trial. Please pay attention to the instructions that I'm about to give you. That is, so just also so you know, after I read 2.7, you all are going to present your closing arguments. The state's going to go first, then you're going to have an opportunity, and then the state has an opportunity for a rebuttal. In fact, that's in the instruction. It says that. So then after those closing arguments have been presented is when I'm going to turn to 3.1 and say, please pay attention to the instructions I'm about to give you. The next instruction I have is 3.2, statement of the charge. Mr. Summers, have you read it and do you agree with it?
Yes, Your Honor.
Thank you. I just like to also look at it myself. I've done it both ways where it says defendant in this case has been accused of the crimes of attempted murder in the first degree. We don't have to say how many counts. That's fine. All right. Next, I have 6.1 introduction to attempted homicide. Is this the one that the standard has the option of abandonment?
Every thing that has attempt.
Has the option.
Yes.
All right. So this is where, Mr. Summers, we're going to have to revisit. First off, have you looked at 6.1, introduction to attempted homicide?
Yes.
It would really be in 6.2 though. Sorry. Is where I would think you would add it.
All right.
Is that just like the generic?
Any objection to the introduction to attempted homicide 6.1?
No.
All right. Next is 6.2, attempted murder, first degree, premeditated. And this is where in the standard instructions, there is actually an option for including abandonment. Is that correct?
Judge, the abandonment language is not in the standard instruction of 6.2. The abandonment language is under 5.1.
Okay. All right, well then let's wait till we get to 5.1 to discuss it, because I don't want to deviate from standards. And if I'm going to give, as is at least right now appears to be requested, any abandonment language, I want to use the standard instruction on it.
Judge, the state did not include 5.1 because, again, it's the state's position that he's not entitled to the defense of abandonment.
Okay, so this is the idea of adding 5.1.
Correct.
Yes.
Because 6.2 is the standard instruction for attempted murder, first degree, premeditated. In other situations, Your Honor, you would have the regular jury instruction, say for a sexual battery. You would have the jury instruction for sexual battery, but you would include 5.1 before the reading of the standard instruction for sexual battery. The Florida Supreme Court created the standard and jury instruction for attempted murder by itself, therefore not requiring the additional instruction of 5.1.
Mr. Summers, what, if anything, is your request regarding these issues?
Your Honor, I would request that 5.1 be included with the packet. I do have a copy of that statement, abandonment of purpose. And if you would like to discuss that now.
Yeah, we are. Is that the same? Mr. Marchese in the beginning had handed me, and I don't know if it was 5.1 or if it was something that was different, but
Judge, he's providing just an excerpt from the statute. He has not provided the standard instruction for 5.1 that includes the defense of abandonment. And I also have case law that I can provide to the court for the abandonment issue.
well, go ahead and tell me. This is when we're arguing. This is where we're arguing. He's requesting. You are still requesting abandonment, even though you previously indicated to me that your legal position is you never intended to do it. Is that correct?
Yes, I'm still requesting abandonment of purpose.
Okay. So let me hear the state's response to his request, and then depending on how I decide, we'll decide where the language is going to come from, if it's going to come from anywhere.
Judge, may I approach with some case law?
Yes, and please provide Mr. Summers
Yes,
copies of
absolutely.
anything you provide to me.
I think I need to get the staples out of the paper, Judge.
Oh.
Yes. She does.
I think there's some up here, if not over there. Probably should take the staples out of mine in the future, too. I'm sorry, Mr. Summers, you're not allowed to have staples.
Well, first, Judge, the state would argue.
Let me just make sure he has them. Mr. Summers, you have, there's 1, 2, 3, 4, 5 cases. You have those cases?
Yes.
All right. All right, Ms. McConnell, you may proceed.
First and foremost, Judge, the defendant has already stated during his previous judgments of acquittal that he did not intend to commit the premeditated act of killing Ms. Mathewson. That alone, in and of itself, does not allow for an abandonment defense, as Your Honor has already pointed out, how can you abandon something you did not intend to do? Secondly, the case of, which I apologize, I did not have a copy of this one printed out for everybody, but it's Carroll v. State, 680 Southern 2nd, 1065, 3rd District Court of Appeals from 1996. And in that case, the court distinguished between voluntary abandonment,
Right.
which
I'm
is allowed by
familiar
law as a defense, and involuntary abandonment. It goes on to describe involuntary abandonment when the defendant fails because of unanticipated difficulties in carrying out the criminal plan at the precise time and place intended, and then decides not to pursue the victim, or when the defendant withdraws because of a belief that the intended victim has become aware of his plans, or because he thinks that his scheme has been discovered or would be thwarted by police observed in the area of the intended crime.
That's involuntary, and that is not a defense.
That
That,
is
under the
correct.
case law, is not something that he would be able to argue.
That is correct.
However, voluntary abandonment, how does that case describe voluntary abandonment, which is a defense?
Voluntary abandonment is a complete renunciation of any intention of committing the crime. So in this case, it would be a complete renunciation of committing the attempted murder, of attempting to kill Miss Mathewson. I provided Dixon v. State, which is 559 Southern 2nd, 354, 1st District from 1990. And in that case, Judge, the court held that once the crimes are committed, as soon as an attempt was effected, the defendant was not entitled to the abandonment defense.
Which case was that? I apologize.
Dixon v. State,
Dixon, I got it.
that case is exactly what we have here, Judge. The defendant committed and attempted to commit by putting a pillow over Miss Mathewson's face, then getting on top of her, putting more pressure on that pillow to the point where she actually loses consciousness. His own self-serving statements in his post-Miranda interview with Sergeant Remia is not sufficient to allow him to have the abandonment defense, because he has already, and even in his own statement, admitted that he effectuated the crime. As far as the commission of the strangling for count 2 with the rope, the state's position is that we have testimony that his actions were thwarted because he believed he saw an undercover police vehicle. That is involuntary abandonment. Therefore, he is not entitled to the affirmative abandonment defense for either count 1 or count 2. The courts have even addressed this issue with felony murder cases. And the courts have cited and stated, even if the actual or the defendant was not included or took part in any way of the murder, if that defendant took part in the underlying felony, they were not entitled to the abandonment defense. That is cited in or discussed in Smith v. State, which I provided 424 Southern 2nd, 726, Supreme Court of Florida, 1983, Kane v. State, 698 Southern 2nd, 1254, a second district court from Second District Court of Appeals case from 1997, as well as Miller v. State, 503 Southern 2nd, 929, a third district court of appeals case from 1987. And in that case, Judge, I'll note that the court considered the defendant's self-serving statements to the police, where he relied upon his innocence. And we have that situation here, Judge, where the defendant is relying upon his statement to Sergeant Remia, where he is saying that he didn't intend to kill her, and therefore he should be entitled to the abandonment defense. So for all those reasons, Judge, it's the state's position that the defendant is not entitled to the affirmative defense of abandonment that would be included in the standard instruction of 5.1.
All right, thank you, Mr. Connor. Mr. Summers' response.
Yes, Your Honor. Quoting Longbow v. State, which is the case that you had mentioned earlier.
Right, yeah, I think I cited 2 cases to take a look at on the abandonment defense, so go ahead.
It states that a defendant is entitled to have the jury instructed on the rules of law applicable to his theory of defense, if there is any evidence to support such instructions, no matter how flimsy that evidence might be.
I agree, well aware of that proposition of law.
And then it says, in determining whether to give a requested instruction, the trial court should consider the evidence presented without weighing it. Ask the latter if a task for the jury. And so that puts it to the jury to decide if there was an abandonment of purpose. Additionally, Your Honor, in according to the instructions on crimes, I'm quoting from the Criminal Laws and Rules 2012, Jury Instruction in Criminal Cases.
What was the rule? I'm sorry?
Defense Rule Section 777.04 5A, statutes.
All right, go ahead.
It says, it is not an attempt to commit crime charge if the defendant abandoned his or her attempt to commit the offense or otherwise prevented its commission, under circumstances indicating a complete and voluntary renunciation of his or her criminal purpose. And, Your Honor, again, I have not testified to trying to kill anyone. The evidence only shows the statement by the victim, the involuntary statement by myself, both show that a pillow was put over her. It doesn't say to kill her. In my defense, it doesn't say to kill her. It could have been to just keep her quiet. It could have been for something we were doing in the bedroom. But the intent to kill somebody has to be easily recognizable. Just because of a look on my face doesn't mean that there's something in my heart that says that's what I intended to do. And there's no statement by me saying I intended to do that. It's only an impression. And it's so the circumstances don't meet the threshold, don't rise to this level of attempting to kill someone. And in that manner, if I didn't intend to do it in the first place, I abandoned any further effort to actually commit that crime.
See, what I hear you saying is there's absolutely no evidence of your intent. Well, the very first element of 6.2, number 1 is, it says to prove the crime of attempted first-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. Number 1 is that Trevor Stephen Summers did some act intended to cause the death of Elisa Summers. So that's your defense, that they haven't proven that you did anything to intend, that you had no intent, that they can't prove intent. I don't understand why you want to argue abandonment when you're saying that in order to support that, there's no evidence that you intended, and that's the exact argument or attack on the elements of their claim. They have to prove you intended.
I understand, Your Honor. And maybe the best way I could explain my understanding of it is this. A moment in time where a decision is made from messing around with a pillow to intending to kill somebody. And maybe it was Mrs. Mathewson's impression that at that moment in time, that split second, she thought she was going to be killed. At that moment in time, I thought this could go further, but I didn't. And so I guess I'm pointing to that moment in time when a decision could have been made to be much more severe. And at that moment in time, that decision to, that potential decision to go more severe was abandoned.
All right. Anything else?
No, Your Honor, those are the ways that I've been able to consult with Mr. Marchese about. That's the best I can explain. I understand it. And I do believe it has some merit.
I thank you, and I appreciate your argument and your position. I will say this. I only make rulings that I believe are not going to be reversed by the appellate court. So I believe that I'm right on my ruling. But I caution the state that if the appellate court thinks that I'm wrong, probably one of the most common reasons I have seen retrials is the court's denial of a requested defense instruction on the law. And the appellate court says you should have given it. I'm not giving it. I'm ruling in your favor because I think you're right. But most of your argument is that it's a crazy defense and there's no way, which are all things that if I gave the instruction, you could argue to the jury. Even though there's just absolutely no abandonment. And that would eliminate any appellate issue of the appellate courts then saying you should have given the instruction. I'm not giving the instruction unless you concede to me giving the instruction because I think I'm right. I think you're right. But the important part of that sentence is I believe that you are right. And I believe that he's not entitled to the instruction. But there's no question if you prevail and he is convicted that that's going to be one of the top appellate issues. And that's the only reason that I say that. So, Ms. O'Connor, it is my intention at this time not to give 5.1 attempt abandonment unless you change your position.
Judge, it's the state's position that the defense's argument is that the state has failed to prove beyond reasonable doubt element 1, that he intended to cause the death of Ms. Mathewson or Ms. Summers during the dates of these offenses. And for that reason alone, he should not be entitled to the abandonment defense.
Okay, I'm not going to give the abandonment defense. I think there's also the other issue that's going around there about I just don't think that you can argue lack of intent and also abandoning something that he never intended to do, just so the record is absolutely clear on the reasons, both reasons, that I am denying his request to give the instruction. So with all due respect, Mr. Summers, I'm denying the request to give an abandonment instruction.
I understand. Thank you, Your Honor.
You're welcome.
Okay, so we're just on
6.2 as is. There won't be any instruction given prior to or any addition to 6.2. Other than, and you're not waiving your objection, it is perfected for the record or your request in my denial. Other than that, any issues with 6.2?
No, Your Honor. I do maintain my objection.
Absolutely, absolutely. It is preserved for the record on appeal. 3.3 is what I have next, aggravation of attempted first-degree murder by carrying, displaying, using, threatening to use, or attempt to use a weapon. Any disagreement, Mr. Summers? Any suggestions or issues?
Yes, Your Honor. I have just a question of the definition. Is it both 1 and 2 or 1 or 2?
I'm sorry, where? Oh, as 2 counts 1 and 2. Yes, both.
Okay, and the weapon is defined as both, is number 1, an object, and so forth, or number 2, an object, or so forth.
That is correct.
Thank you.
You're welcome. Any other issues, questions regarding 3.3a?
No.
All right. Next, I would give 9.1 kidnapping, which is as 2 count 3. Did you put that? No. Any issues regarding 9.1 kidnapping?
No, Your Honor.
All right. And you do see, I notice now, because element 3 says that Trevor Stephen Summers acted with intent to commit or facilitate the commission of grand theft motor vehicle. Right under that, it says, see the definition for grand theft motor vehicle, which is in count 10, which we will ultimately get to. So it's actually instructing them to go forward to count 10 to see the elements of grand theft motor vehicle. You understand that?
Yes.
And have a problem with that? Okay. Next is 11.4 sexual battery. 4 elements. And we have to eliminate at least the italicized give if requested.
I was just waiting to see if they requested it.
Is the state requesting that?
Yes, Judge, we are.
So, Mr. Summers, do you have any comment on that? What they're requesting, that line after give if requested?
Yeah, I would ask that be removed.
Remove?
Yes.
Do you intend to argue that? What it says is that her lack of chastity is not a defense to the crime. You intend to argue that the defense is her lack of chastity?
Honestly, Your Honor, I don't see the relevance, but that's just mine.
It's part of the standard, and the instruction says give if requested. The state is requesting it, so I am going to give it. But we're going to eliminate that language that says give if requested.
Yes, Your Honor.
All right.
Thank you.
You're welcome. Next, I have 16 points.
This is the one where the proposed.
Oh, okay. So I don't have it on mine. This is
It's
the
that
one we handed out. Yeah, thank you. Where did I put that? Here it is.
And I've already added count 9 to that.
Okay. All right. So what I am proposing here, if you look at 16.6 neglect of child on page, in this stack is 23, then you would have on page 24 also 16.6 neglect of child. Then after that, another neglect of child. Then after that, another neglect of child. Then after, so that's the total. The only difference in all of those instructions is the initials of the child. So what I've proposed and what was handed out prior to court beginning this morning is 16.6 neglect of child, but in paragraph 1, including all of the different initials. So it would read as follows, just for the record, and we'll put a copy of it in the record, and we'll see if anybody has any objection. Trevor, number 1, would read, Trevor Stephen Summers willfully or by culpable negligence failed or omitted to provide A.S. count 6, L.S. count 7, and or B.S. count,
It'll be BS count 8 and or GS count 9.
Okay. With the care, supervision, and services necessary to maintain AS count 6, LS count 7, BS count 8, and or GS count 9, physical or mental health. And then in 2, it says Trevor Stephen Summers was a caregiver for AS, LS, BS, and it'll say and or GS. Same with count 3. So same theme here. It'll be AS count 6, LS count 7, BS count 8, and or GS count 9 were under the age of 18 years. Does everyone understand that consolidation into one instruction?
Yes.
Thank you, Mr. Summers. State?
Yes, Judge. I just think that, and I don't know if maybe that, I know there is an instruction that you need to consider each element separately and distinctly from each and every other count. I don't know if we need to maybe add something that they are going to have to make the determination as to each element, as to each victim. It's on the verdict form and clear, but because we're putting it together, I don't know if we need to add any language.
I tell you what, we're going to spend more time talking about it than me reading. It's a half a page instruction 4 times, so I'll just read it 4 times. So forget what I handed out to consolidate. 16.6, count 6 as to AS. Any objection, Mr. Summers?
No, Your Honor.
Next is 16.6, neglect of child, count 7 as to LS. Any objection?
No.
Next is 16.6, neglect of child, count 8 as to GS. Any objection?
Yes. I need it to be corrected
To BS.
to BS.
Judge, would the court consider
Wait, State, do you agree that it should be corrected to the correct initials of the child,
as to count 8? Yes,
which is instead of GS, BS?
correct.
All right, I just want to make one change at a time. If we all agree, my staff attorney can make that change. So GS is being changed to BS. Now, Ms. Johnson, you had something else.
Once you read the entire instruction as to count 6, I don't know if the court would want to say, the further definitions given, I read to you previously. So they can still be there on the form, but you don't have to reread them. Neglect of a child, the definition for caregiver, and the definition for culpable negligence when you read 7, 8, and 9.
I would just stick with the standard.
Yeah, let's just stick with the standard and a bunch of caution. I appreciate that, but if I'm not going to consolidate them into one, I don't want to do something
That's away from the standard.
to deviate from the standard. So go back to the one where we made the changes. That was count 8. Now says BS. Other than that, Mr. Summers, any questions, issues, objections?
No.
Next, I have count 9, which is also 16.6, neglect of child, and this one is now GS. Any objections?
No, Your Honor.
All right. Next, I have 14.1, grand theft motor vehicle, which is count 10. It is 1 page, full page long. Mr. Summers, any issues, objections, questions?
No questions, no objections.
Thank you. Next, I have, well, you know what? Just to be for the record is clear, you said no questions. Any objections?
I said no questions, no objections.
Oh, I'm sorry. I didn't hear the second part. I appreciate that. Thank you. Next, I have 8.18, which is as to count 11, violation of an injunction for protection against domestic violence. Mr. Summers?
No issues.
All right. Next, I have 3.4, when there are lesser included crimes or attempts, and specifically the lesser included crimes that are indicated in this instruction for attempted first degree murder are attempted second degree murder, attempted manslaughter, attempted aggravated battery, and attempted battery. There are the lesser crimes indicated for the definition of kidnapping is false imprisonment. The lesser crime indicated in the definition of sexual battery is battery. And finally, the lesser crime indicated in the definition of child neglect is culpable negligence. Any questions, issues, or objections to 3.4?
None for me, Your Honor.
All right. I accept that there's none from the state since it was what the state proposed. So, state, that's why I'm not asking you to chime in unless you would like to.
Yes, Your Honor.
Next, I have 16.1, introduction to attempted 6.1, introduction to attempted homicide. It is 1 page, full page, and then goes over to 2 lines and a portion on the next page. Mr. Summers?
Just a question, if
Yes.
this is required to be in here again? It's already at the beginning of the packet?
State, why is it in here twice?
It says in the instruction that it needed to be offered again, but if you want to say, please refer to 6.1 for the introduction to attempted homicide before you read it's on underneath the list of the lessers. Down at the underneath the box, it says you need to reread the instruction to attempted homicide. But if you want to just put a line, see instruction 6.1 prior to attempted first degree murder.
That's the way I've seen it before.
That's
That's
fine.
pretty common.
I was just trying to have more. It's easier to take out than to add.
Yeah. I don't have an issue with that. And that's why we have this charging conference and can discuss, and that's, can you make that change?
Yeah, but so you want to, is this like under 6.4 or you just want 1 page that says, please refer to 6.1?
I think
No.
it needs to go before 6.4. It needs to be above it somehow.
Okay. I can leave the 6.1 heading and say, please refer to.
That's what I've done before.
And that sounds familiar, so I think I see. So, Mr. Summers, you actually suggested or asked why it's in here twice. So what we're doing now is proposing to take it out the second time and simply put to see the other time.
Okay, so you're going to have a page that just says 6.1, introduction to attempted homicide. Underneath that, it's going to say, please refer to instruction 6.1 as previously given.
Yes.
Good?
Okay.
Yeah, and you're all right with that?
Yes.
And state's all right with that?
Yes.
All right. So I'm taking that 6.1 out and putting it in the garbage. 6.4 attempted second degree murder, and this is the lesser as to counts 1 and 2. It is, I believe, 2 pages. It goes on to the second page. What I'd like to, if we can, I don't like the spacing where I have
got
it.
to reformat it all. So just
Oh, okay.
don't get attached.
So there may be some reformatting. If you see the one you have, in section E, it ends with Elisa, and then on the next page, all it has is Summers. So we're just going to reformat that. But as to the content, is there any issues or objections or questions, Mr. Summers?
I do have a question or an objection, both. I was not aware that there would be these types of other options for the jury, so I'm not very prepared to argue or include these in any kind of closing argument. I don't know if that's a valid objection, but I just want to state for the record that I'm a little bit surprised by these lesser offenses, and I believe that it diminishes my ability to.
I understand. I hear you. But I'm going to say that this is perhaps one of the disadvantages of representing yourself as you chosen. The law includes Category 1 lesser included that are required to be given to the jury. These are actually Category 1, and the jury must be instructed on them and have the option of finding you guilty of something lesser than the crime that is charged. And then these are all of the Category 1 lesser included instructions. So,
I understand. I thought this was an option for the state, not a requirement. That's the difference.
Category 1s are required. Any issue, any difference, or comment from the state?
No, Judge.
And let me just verify. I verified that, well, all of the ones that you've included are in fact Category 1 lessers. Is that correct?
Only Category 1, Judge.
Okay. Now, all right. So I just want to verify. The law says Category 1s must be instructed, even if the defense says, I don't want them instructed. All right. So other than that question, sir, any objection regarding the content of 6.4, attempted second-degree murder?
No, Your Honor.
All right. Thank you. Next, I have 3.3a, aggravation of attempted second-degree murder by carrying, displaying, using, threatening to use, or attempting to use a weapon. And this is as to, I apologize, this is as to counts 1 and 2, Mr. Summers.
Yes, I understand it, Your Honor, and I'm just double checking it with the first. So is this a duplicate of page 20?
You don't.
Sure is. But if it is clear that A applies to either the lesser, not one or two.
It's the same language. But this is where they're being informed that this aggravation also applies to the lesser of second degree, second degree. As I sit here, I don't recall any consolidation. I think on this one, it is perhaps redundant, but I don't recall ever consolidating it. It's going to get pretty confusing. I'm concerned if we do anything else. Trust me, I'm no happier than anyone having to read all this stuff twice. They're all 60 pages. But other than State, did you have any comment?
Not as to that, Judge. We do need to revisit 3.4 whenever we're done addressing this issue.
Which was the previous one?
3.4 is the lesser crimes included. It needs to say the lesser crime included is attempted second-degree murder.
With a weapon?
No, they just. I'm sorry, Judge. That's incorrect. Can you just get the position?
Okay, and give me a moment, and so we can all turn back to it.
It should be about page 30,
Page.
maybe.
What page are we referring to?
My pages are
State. This is why we do these charging conferences, so we can determine any issues before I'm reading. It's actually on page 29, Mr. Summers. It's the 3.4 lesser included crimes and attempts. And I apologize, Ms. Johnson. Tell me specifically what the issue is.
So, Judge, I guess we're questioning the charge for counts 1 and 2 is attempted murder in the first degree with a weapon. So do we need to list a lesser is attempted first degree murder, period, with no weapon? But I had the special finding on the verdict form where they would make a finding as to he's guilty of attempted degree murder, and then they make the special finding. But I don't know if we need to list that attempted murder in the first degree without a weapon is considered
What's
lesser.
standard? What have you done before? I mean, what do we usually do?
Well, in another case, Miss O'Connor did the attempted murder in the first degree without a weapon. She didn't put without a weapon, but just attempted first degree murder was considered a lesser.
Yeah, it is lesser.
Well, I'm concerned also that the lesser crimes indicated in the definition of attempted first degree murder should then say attempted first degree murder with a weapon, because it wouldn't sound right if that didn't include weapon and the second one it also didn't include weapon. There has to be some distinction.
Correct. So we would need to fix that.
So that would add an additional, and let me, I mean, there's a chart. I don't have it in front of me, but
So it doesn't have for attempted first degree murder. It doesn't verify. There's not one for with a weapon and without. It's just attempted first degree murder, and then you have the aggravation for with a weapon. So there's not a chart for attempted first degree murder with a weapon. It's just attempted first degree murder.
So we can't say it's a category 1 lesser if it's not on the chart as a category 1.
It's right. It's not a category 1 lesser.
Yeah, I mean, it makes
the weapon
sense.
is a special finding. It's an aggravator. So that's
Right.
why I did not include it. But
Right.
I know you've had other cases where you have included it.
Well, what's your request? Your request is not to include it because that was the proposed instruction. Mr. Summers, do you want... This is one I think that it's appropriate to allow Mr. Summers to weigh in on if it's not a category 1, because he didn't appear to want any of the lessers, and I told him they're category 1s and they have to be given. So if this isn't a category 1, I think it should probably ultimately be left up to him. And the state didn't originally request it, so I'm assuming the state didn't want it. Mr. Summers, do you understand what we're discussing?
Yes, whether or not to include the lesser with
Of
the,
simple attempted first degree, simple, the word doesn't even go with that, but of attempted first degree murder after attempted first degree murder with a weapon.
right. I believe it should not be there.
Okay. Do we need, though, anything about the weapon? I think I agree with Ms. Johnson that that's just an additional finding. That the charge, should it say? I want it to track, though, count 1 and 2. I apologize. Jury instructions, sometimes they're very tedious, and no offense to the Supreme Court, but complicated. But that's why I take time and want to make sure that they're absolutely correct. So does the state have a position on the lesser crime indicated in the definition of attempted first degree murder are, or should it say definition of attempted first degree murder with a weapon? It's not in.
No, she just did it as the instruction on aggravation, right there.
And a finding,
As
yeah.
a finding. So I think it's fine now.
I think it's fine this way too. Miss, I mean, this is the opportunity.
Can I just have a moment, Judge?
Yes.
Is for the moment, Judge. Maybe readdress it at the end.
Okay. Yes, absolutely. Leave it as proposed
Correct.
and as requested by the defense. So, that's right. I'm at 3.40. We have something else?
Really, we left off on 3.3a, the second reading of 3.3a, which is after that.
Oh, so we were actually one part. No, it's not after.
Well, it should be. It should be. Yeah, you're out of sorts.
So what page should we be on? I'm sorry. When I flipped back to that lessers,
Because this is where we started. Are we going to do a second reading of this?
I think we agreed that we were going to do a second reading of 3.3a. That was my ruling, and I'm going to stick to it. So moving on from 3.3a is now 6.6, attempted manslaughter by act. Mr. Summers, any issues, objections? And this does have one of those italicized and in parentheses, the explanation of justifiable attempted homicide and excusable attempted homicide are in instruction 6.1, introduction to attempted homicide, which was previously given. You see that
Yes, Your Honor.
note on there? So that we're not doing it twice.
Understood.
So do you want me to italicize that, or do you want me to cut that?
No, that needs to stay.
Well, you already say, as I have previously instructed you.
Oh, as I previously instructed you, yeah. Mr. Summers, do you have any problem with just eliminating what's in the parentheses because that's preceded by as I have previously instructed you?
No problem.
State, why was the italicized and in parentheses language here? Were you requesting it?
Judge, it's included. The italicized part is on the standard instruction, so I'm not sure if this is a situation where because it's italicized, taking it out versus the Supreme Court putting it in there to then allow Your Honor to simply read that saying this is where refer to 6.1 for that definition. I think
My recollection, I mean, and I could be wrong, trust me, I'm not always right, but is that it ends in the past, that it ended there, as I have previously instructed you, period. This language I haven't seen before, but I'm not questioning you on that it's included in the standard. Do you have the standards up?
Hold on.
Yeah, just let me take a look at the standard to see if it has.
sure.
Typically, it's in italics. You don't read it.
I think that's just in the standard letting you know.
Right, and that's
So are you requesting?
refers back to the instruction of 6.1. So it's fine if you want to take out what's italicized in the parentheses.
Well, I guess what I'm trying to figure out is why it's in the proposed instruction. Were you requesting that I read what's in the parentheses or not requesting it?
Judge, I left it in there because I wanted the court to know that that was in the standard instruction. So we just need to make sure we address it. However you want to address it is fine, but I wanted to make sure that we didn't forget to address
All right. Well,
it.
the proposal is that we take it out, and I think that Mr. Summers is in agreement, correct? All right. So I'm taking it out. Next, I have 3.3a, aggravation of attempted manslaughter by act by carrying, displaying, using, threatening to use, or attempting to use a weapon. This is a lesser as to counts 1 and 2. Issues, questions, objections, Mr. Summers.
None from me, Your Honor.
Next, I have 5.1, attempt to commit aggravated battery, lesser as to count 1. And why isn't it as to count 2, State? Also, taking a look at the first 2 sentences, it's kind of redundant. Is there a way that we can change that or address that? See how it's, I can't imagine that both of those are required.
I need to pull up the original instruction. So attempted aggravated battery is a category 1 lesser.
I mean, it says the same thing in those 2 sentences. They're slightly, ever so slightly different. I don't care which one we use.
We need the top one, Judge, not the second one.
All right, Mr. Summers, do you see how those first two proposed sentences are practically identical, but it's just repeated twice?
I do.
Do you have any problem with removing the second one?
No.
All right.
And Judge, for the record, for 5.1, the standard instruction for attempt to commit crime, that first paragraph, it says to use when attempt is charged or is a lesser included offense. So that is the more appropriate one to read.
The top one?
Yes.
Okay, not a problem. I accept that. But why is this only a lesser as to count 1 and not a lesser as to count 2 was the only question I had.
It needs to be as to both, Judge.
All right, we'll make those changes. Mr. Summers, do you disagree?
No.
Okay, we have the same thing in the second paragraph. The crime of aggravated battery is defined as, and then to prove the crime of aggravated battery, the state must prove the following 2 elements. One of those has to come out. Which is in the standard? Or which one is pursuant to the standards more appropriate, Ms. O'Connor?
I'm sorry, Judge, where are you at?
Just under element 2, it says the crime of aggravated battery is defined as, colon, then under that it says to prove the crime of aggravated battery, the state must prove the following 2 elements beyond a reasonable doubt. The first element is a definition of battery. I think the second one is more appropriate. I think that first one that's just left hanging there is, I don't know why it's there.
Because that was probably the beginning part of the actual aggravated battery instruction.
So is that a typo?
So in the standard for 5.1, it says the crime of, and then you put the crime attempted is defined as, and then you insert the elements of the crime attempted. So
Does it make sense to have both?
no, I don't
I
think it
think
does.
either works. The second is a little longer and has the explanation of the first element is a definition of battery. I will tell you that my preference is for that one. Any objection from the state?
We defer the court, Judge.
Any objection, Mr. Summers?
No, Your Honor, whatever you
I'm
prefer.
scratching the crime of aggravated battery is defined as, colon, that's coming out. Anything else that spills over onto a second page. So make sure that we're all on the same page as to reviewing 5.1, attempt to commit aggravated battery. Any other issues, questions, objections?
I believe it should say the first element is a definition of battery and is defined as 1 and 2.
That's not the way the standard language is. I'm going to follow the standard language. You may have an issue with the Supreme Court and think that it could be done better. I sometimes might say the same thing, but I'm not going to say that. But I'm going to follow the standard, and that is standard.
Okay.
All right. Any other questions, issues, or objections as to 5.1?
No, no.
All right, thank you. Next, I have 5.1, attempt to commit battery.
And again, there should be lesser as to counts 1 and 2.
And it says that it's a lesser as to count 2. Is there any reason why it's not a lesser or should not be a lesser as to counts 1?
Judge, I think the instruction we just went over needs to say lesser as to count 1 and 2.
We made that change.
So this can be taken
So
out.
now we're at 5.1, attempt to commit battery. That's in a different lesser. And it only says count 2, but it should say count 1 and 2. The other one said only 1 and should have said 1 and 2. This one says only 2, but should be, I think, 1 and 2. I'll give you a moment.
Judge, there was a reason behind this,
Okay,
but I
well-
cannot remember at the moment. It was a conversation that I had with Mr. Marchese, but I
I'll
can't
give you a
explain it right
moment
now.
if you need a moment.
No, Judge, I think that the way we previously discussed it is appropriate. It should be under 1 and 2. It should need to say lesser as to 1 and 2.
Okay, Mr. Summers, any disagreement, questions, or objections?
No, I understand. I agree. 1 and 2.
No. Sorry, you got this again.
In the body of it, it says the crime of battery is defined as colon. Then under that, it says to prove the crime of battery. I'm striking the crime of battery is defined as colon. Any objection, comments, or questions from either side?
No.
I agree with that. And the same thing for the top of the page, to prove and then in order to prove.
He's right. Which one did we do?
Top one.
The top one? Thank you, Mr. Summers. I'm scratching in order to prove that the defendant attempted to commit, and I'm simply leaving to prove the crime of attempted battery. The state must prove the following 2 elements, and then it'll go right into the 2 elements instead of the sentence that is on the paper that you see. Any objection, state?
No, Judge.
Next, I have 9.2, false imprisonment, lesser as to count 3. Mr. Summers? Objections, comments,
Nothing from you.
questions? Thank you.
The only thing I noticed, and I'm not sure if it's on yours, is that
Mine is what you gave me, so
The victim's name needs to, for the definition of secretly, it needs to say Elisa Summers where it says victim.
okay. Mr. Summers, any objection to changing what is now in parentheses and says victim to the actual name of the alleged victim, Elisa Summers?
No, I understand.
All right. That change is being made as we speak. Next, I have 8.3, battery, lesser as to counts 4 and 5.
I just put the victim's first name. We need to add Summers.
I see Summers in.
Oh, no.
It's in there twice.
Yeah.
Oh, okay. It's in there 3 times. Twice it has Summers, but 1 time it has Elisa. Mr. Summers, do you see that? It's actually in the element 1 towards the end of that first sentence where it says touched or struck. It just says Elisa. We're going to add Summers as it is the first time and the last time that her name is mentioned.
I understand.
All right. Any other issues, questions, or objections related to 8.3?
No, Your Honor.
All right. And you made that change. You added Summers? Next, I have 8.9, culpable negligence, lesser as to count 6.
Okay, this will be 6, 7, 8, and 9. We only need to do this once. I just need to add all the additional. Oh, we didn't make that change. I'm
No,
sorry.
yeah, no.
But you don't want to make the change on this one? Okay.
No. We're going to leave it as is. Mr. Summers, any questions, objections, comments? It's going to repeat now 3 times.
I understand. No problem.
4 times. All right. Okay. Next, I have 8.9, culpable negligence, lesser as to count 7. Same language, except that the first one was AS, the second one is LS. Anything, Mr. Summers?
No, Your Honor.
Next one is 8.9, lesser as to count 8, and the initials are BS, which is correct, right? No?
Yes.
Yes. Next, I have count, and just for the record, Mr. Summers, no objections?
No.
Next, I
There's
think
the spacing on lesser to count 8 just needs to be fixed there for 1 and 2.
I'm good. I've got it.
Okay.
you're fixing that?
I got
Alright.
the whole thing needs.
We did say we were reformatting, and you will see that. We'll print it out so that you can see it. But what I'm most concerned about is the content, and then we will reformat, send it to you, and if you have any objections or issues, I will ask you once you've been given the final copy after reformatting if it creates any issues that you wish to raise. Next, I have 8.9, culpable negligence as to count 9, and the initials are GS is the only difference in this one.
Yes, other than just the spacing on number 2 as well. That's it.
All right, we're fixing that. Next, I have 3.7, plea of not guilty, reasonable doubt, and burden of proof. Mr. Summers, you have an opportunity to review that.
Yes, I have.
Any questions, objections related to that?
No, Your Honor.
All right. Next, I have 3.9, weighing the evidence. Now, this one is going to require us perhaps to take a look. There's 9 individual enumerated paragraphs, and they don't usually always come in. They're not always appropriate. So let's take a look and see if any of 1 through 9 should be eliminated.
I think it's only starting at 6, Judge. 1 through 5 are standard.
Right.
So the state's position is 6, 7, and 9 are not appropriate.
Not appropriate?
6, 7, and 9.
All right, Mr. Summers, I need you to look at 6, 7, and 9 and either agree, disagree. The proposal is to take out 6, 7, and 9.
I would leave 7, Your Honor.
Any pressure or threat used of the witness's testimony? I'll leave it. I'm going to leave 7.
Okay, hold on. So I'm cutting 6.
You agree, Mr. Summers, to eliminate 6?
Yes.
Okay.
Not 7. We're going to keep 7.
I'm sorry, Your Honor. I believe preferred treatment would also be important. I would leave 6.
Has the witness been offered to receive any money, preferred treatment, or other benefit in order to get the witness to testify? What, if any, evidence do you propose suggests keeping that in?
I believe just the number of media interviews, press releases, all these things that witnesses have done in this case.
I don't know if there's any evidence of that before the jury.
I'm sorry.
You can only argue evidence that was admitted during the trial.
Okay.
All right, so 6 comes out. You want 7.
Yeah. Well, Your Honor, back to 6. Is there any preferential treatment based on the cameras and media coverage of this trial in this courtroom?
I mean, I don't know. I'm not answering questions. Is that your position now, that you think that's appropriate, that you're going to make some argument as to that effect?
I believe it has some merit.
So you intend to argue that the credibility of some witnesses were affected by the presence of media, even after the instruction that I gave specifically to the jury to disregard and to not let that affect them in any way?
I won't be arguing that closing now.
All right, then so we're going to eliminate 6. 7, though, state is suggesting we eliminate, but you would like to keep. Is that still correct?
Yes, sir.
And I'm going to keep it. 8, state did not request to take that out. 8 appears to be appropriate. There were some on both sides, and there were references to prior inconsistent statements. But I just want to verify. State, you're not asking 8 to come out, correct?
Correct.
And Mr. Summers, you're not asking 8 to come out.
No, Your Honor.
Say 8 remains. It becomes 7. Now, number 9, I don't believe there was any evidence of that. Mr. Summers did not testify. So, state, you're suggesting 9 comes out. Mr. Summers, are you in agreement?
Yes.
All right, 9 comes out.
Okay, sorry, just to confirm. So
Yes.
we have 1 through 7, with 6 now being, had any pressure or threat been used against the witness, and number 7 being, did the witness at some other time make a statement that's inconsistent?
Correct.
Okay.
Mr. Summers, you agree?
I agree.
All right. Moving on from 3.9.
Well, Judge, we need to make
Oh,
sure
yes, you're absolutely
that-
right. I forgot that it was second. It was 2 pages on the. You probably proposed 2 of them. No, all right.
I got it. Yeah.
We got to take a paragraph out that says that he became a witness. It's on the second page, Mr. Summers. Do you see? It's 2 lines about the middle of that those paragraphs. It says the defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you apply to the testimony of other witnesses. We're going to scratch that. Do you agree, Mr. Summers?
I do.
All right. As to everything else, though, Mr. Summers, are you in agreement?
Yes, Your Honor.
State no other changes proposed? Next is 3.9A, defendant not testifying, which is absolutely appropriate under the circumstances. Mr. Summers, take a look at it. Let me know if you have any objections, questions, or comments.
No objections, Your Honor. No questions.
All right.
No comment.
Thank you. Next, I have 3.9, defendant's statements. There were statements that were introduced into evidence. So, Mr. Summers, any questions, comments, or objections?
No, Your Honor.
All right. Next, I have 3.9C, eyewitness identification, with specifically enumerated 1 through 9. Mr. Summers, any objection?
No.
Next, thank you. Next, I have 3.10, rules for deliberation, with enumerated paragraphs 1 through 7. Mr. Summers?
No.
Next, thank you. Next, I have 3.11, cautionary instruction. Anything, Mr. Summers?
No.
Thank you. Next, I have 3.12, verdict. We're going to talk about the verdict in just a second, but first, as to the content of this instruction, 3.12. Anything, Mr. Summers?
No, Your Honor.
All right, thank you. Now we're going to look at the verdict form, and there may be some changes based on some things that we've decided. I don't know that to be a fact, but we're going to go through each and every page of the verdict form to make sure that it is correct and appropriate. So, starting on page 1, the jury will find as to count 1, and then there are instructions, and there are choices A, B, C, D, E, and F. B, C, D, and E include the lessers that we've previously discussed. I don't think we've made any changes related to those. Mr. Summers, any issues regarding count 1?
Your Honor, is it appropriate? Is this a standard format?
It should be. It appears to be. There is a standard verdict form in the instructions. What is your issue or question?
At the end of A1 and B1 and C1, it's an attempt to use a weapon instead of the alleged weapon.
No.
Is that ambiguous? No.
It's not standard language. This is standard language on those specific things.
Okay. Then no question with count 1.
Okay. As to count 2,
Judge, the only thing that I think we need to take out as charged on the A part, because he's charged with attempted first-degree murder with a weapon.
it's the finding that
Makes it as
it.
I know.
So I agree with her. It's just scratch as charged, and then all the rest would be lessers.
Mr. Summers, any objection?
No, I understand.
All right. I'm scratching as charged. As to count 2, there are choices A, B, C, D, E, and F again.
And I think we need to
Take out as charged. Mr. Summers, agree?
Yes.
Taking that out, any issues, Mr. Summers?
No.
After that, as to count 3, there are choices A, B, and C. B is the lesser.
Understood.
And as charged remains. It's appropriate in this one because there's no special findings under A. Next, I have count 4 with choices A, B, or C, with B being the lesser. Mr. Summers?
No issues.
All right. Thank you. Next page, page 3 of the verdict form, starts off with count 5 with 3 choices, A, B, and C, B being the lesser of battery.
Judge, we need to go back to count 4 and 5. We need to do the special finding for the penetration. We can send that language to, yes, we'll send the language.
Well, we probably have it in the standard. I imagine that it's in the standard.
It's not, it's the special finding language, Judge. I can,
She could just email it. That's
All right. Well, I just want to make sure that I read it and Mr. Summers is aware of it and is given the opportunity to comment.
we can pull it up and read it now, Judge, and then we can send it.
All right. Read the language that you're proposing be included in counts 4 and 5. If it's a special finding under count A, Mr. Summers, what that means is just like in counts 1 and 2, there's that question where the jury finds yes or no. This is going to be a question, an interrogatory type form of question for the jury to find if they select count A, guilty of sexual battery by a person 18 or older upon a victim 18 or older as charged. There will then be a question for them to answer. And that question, the language of that question is?
Judge, it would be, did the defendant's penis penetrate the vagina of Elisa Summers? Yes or no?
You understand that, Mr. Summers?
I understand that. Is that an enhancement to the charge?
It's for the score sheet to get the penetration points.
It can't affect your sentence, so that's why the jury has to find it.
And do we also need another instruction within the first part of the packet with the charges?
It includes penetration or union.
It has that definition. That's one of the findings in the, it's in the elements, I believe, correct?
Yes, Judge, it's one of the elements.
Can you read the language one more time? The question?
Did the defendant's penis penetrate the vagina of Elisa Summers? Yes or no? Just, it's almost, the finding is similar to the findings of the aggravation for the weapon.
No, I understand. Any other questions, Mr. Summers? I do believe it's appropriate and required.
No, it's just in 11.4 it says sexual organ of Trevor Summers, not penis, but I don't know if that matters.
State, what's your response? I prefer to be as consistent.
I would agree, Judge. Let me inform them. That's fine. So we would say, did the sexual organ,
So in the question, the interrogatory, instead of penis, will say organ
sexual organ?
to be consistent with the instruction.
Correct.
Mr. Summers, you all right with that?
Yes, I'm fine with that.
Okay.
I still am wondering if we need an additional instruction in after 11.4 for that enhancement or not. Or I'd like an understanding of why we wouldn't need that, just like we have the additional enhancement under.
It's not an
Attempted
enhancement.
Well, if he's making a response, I'll give you an opportunity to respond to his response. So he's making a request, and I'll give you an opportunity to respond. So that's your request,
Yes, I'm.
that we include information in the instruction regarding this question.
Yes, the same way that there's instruction for the with a weapon, this would be with a sexual organ.
Well, I suspect their response is going to be that one is an enhancement. This is for purposes of a finding that is on the sentencing guidelines. State, what's your response?
That's correct, Judge. So the aggravator for the weapon takes the level of the offense up a level and a degree. This does not change the level of the offense or the degree of the offense. It simply is for us to be able to get the penetration points on the score sheet.
Which ultimately could affect the sentence, and thus is required that the jury make a specific finding.
Correct.
All right.
Understand.
Okay.
Thank you.
You're welcome. What count were we on?
5.
5? Oh, I'm sorry. Yes, 5. So now 5, choices A, B, and C.
Any
Any,
special finding under A.
right, because this is the same sex batch. So the same change under A as to count 4. Count 6, choices A, B, and C. And this is going to be the same on 6, 7, 8, and 9. So, Mr. Summers, I'll let you take a look at, and then if you have any comments, questions, or objections as to the language on the verdict form regarding count 6, 7, 8, and 9.
No, Your Honor.
All right, I do have a formatting issue.
I don't get attached to formatting.
Okay, so just so you know, and when you get the final version, it's not going to look the same. You can take a look at, but the way it leaves the hanging from the page 3 to 4 is not going to be that way. There will be no hanging. We, the jury, as to count 10, choices A and B, there's no lessers. Mr. Summers?
Understood. Thank you.
You're welcome. As to count 11, choices A and B, no lessers.
Yes.
All
Understood.
right. All right, that's the verdict form. So, with those changes that we discussed and agreed upon, is there any objection, Mr. Summers, to the form of the verdict?
No, Your Honor.
Next, thank you. Next, I have 3.13, submitting case to jury. Questions, comments, or objections?
Your Honor, I believe you read this to the jury already, correct? You need to read it again?
No, I don't think so. This is, I shouldn't have. 3.13, submitting case to jury. I mean, there may be some similar language that was in one of the introductory, but it wasn't.
Yes, there's some similar language. I understand it. No question.
No objection? All right. That's the last instruction that will be given to them before I send 6 of them back to deliberate. I will let them know and ask. Looking for my chart. Do you have an extra chart for me? I'm sure mine's up here somewhere, but. So we're all on the same page. I will be letting number 7, Anthony Tadone, and number 8, Dawson Lefevers, know that they are alternates and they will remain behind, and I'll send the rest of them back. I'll also let them know that the evidence, the instructions that I read, and the verdict form will be coming back to them momentarily. I will give you all an opportunity to take a look at any or all of that you wish to before the bailiffs take it back into the jury room. We also are going to need to have a clean computer back there if they want to listen to or view anything.
Yes.
Okay. And I'll request that you show that to Mr. Summers so that he can verify any of those things, including the evidence, the instructions, and the verdict form before it goes back.
Yeah, so there's no DVD player back there.
Apparently there is, but it doesn't work.
Okay.
Much like the equipment in the courtroom.
2.13, did we address that? That was included in the packet. I don't recall hearing that.
I don't know. What is it? Tell me what it said.
It's the prior inconsistent statement as impeachment.
Oh,
It would have come after 2.7 in the packet.
Okay, so
let me just find it.
it's
That was in the very beginning with some like the
The Williams rule, the edited instruction, things like that. So I'll leave it up to Your Honor and the defendant if they want to include it or not.
'cause, yeah.
Or it was never used, so then it wouldn't be included. in
right.
the
I
trial.
thought that was an instruction that's read during the trial. If it comes up, we have the instruction that talks about prior inconsistent statements in weighing the evidence. I apologize. I had it in front of me. Can you read it to me? It's up here somewhere.
The evidence that a witness may have made a prior statement that is inconsistent with his or her testimony in court should be considered only for the purpose of weighing the credibility of the witness's testimony and should not be considered as evidence or proof of the truth of the prior statement or for any other purpose. But I think you're right, Your Honor. I don't think it would have been read before this
Right,
would have happened,
right.
which it was not requested.
Right. Yeah, and I found it, and I found my chart, jury chart. So, no, it's included in weighing the evidence. There is a specific enumerated that we went over and we ultimately all agreed upon they will be instructed on weighing the evidence regarding prior inconsistent statements. All right, so the next step, I'll give you all a short break, but the next step is to bring them out, do the closing arguments. State, you have any idea approximately? Are you splitting? Who's doing closings?
We're splitting it, Judge.
Who's going first?
Miss O'Connor.
All right, approximately, I know that you probably don't have a iPhone that you can put up in front of you and stick to necessarily what you tell me, but if you could give me a rough estimate of time, just so that I can pre-plan if I need to take a break, give the jury a break. How long do
30
you
minutes
believe
max.
total? I'm sorry?
30 minutes for me.
And Ms. Johnson, your rebuttal?
45.
Okay, so an hour and 15 total from the state. Don't have to use all of it, but estimate an hour and 15. Mr. Summers, any idea of how long you intend to argue to the jury?
About an hour.
Okay. And let me just tell you that that is not an opportunity for you to testify. You did not testify. It is absolutely an opportunity for you to argue your case, but your argument will be limited to any of the facts and testimony that was introduced during the course of the trial.
Understood.
You can't add new stuff. You understand that?
Yes, and would you like me to address when I'm speaking of myself as me, myself, and I, or as Mr. Summers?
I do not care. That is, I am not going to tell you. I do not have any preference. It is entirely up to you. However you wish.
Okay, I just didn't want to be construed as testifying.
Well, as long as you're not adding new evidence, and so if you're talking about stuff that was in evidence, including statements of yours that are in evidence, but whether you refer to yourself as Mr. Summers or I said, that's entirely up to you.
Thank you.
Say, do you have a position on that? I mean,
No, Judge.
okay. All right, let's take, I suspect, I don't know how much of the 45 minutes, we took all the 45 minutes, I suspect. I'm way over?
Stay texting you.
Oh, all right. Well, is it?
About, no.
They're back?
Yeah, they've been back since 9:30.
Wow. We took 2 hours with jury instructions?
An hour and a half.
All
We
right.
only gave them 45 minutes.
All right. Okay. Well, I want to give them a short break, and we'll print all that out. What I suspect, because the instructions are very long, okay, I suspect that if things go as planned, I will be giving them a break before I begin the reading of the instructions. I mean, they're going to have a break. If each side's going to take, an hour, and the instructions are going to take a good part of an hour, we will plan on having them lunch at an appropriate time. It may be later in 12. We'll figure that out when we determine what time we're getting started. But I suspect the plan will be to have lunch ready for them when they go back after closings from both sides and instructions from me. I don't know exactly how long it's going to take. I'm often accused of reading too fast. So I will try, even though there's a lot of instructions, to be aware of that and not read too fast. But it's going to take a while to read 60 pages of instructions. So that's the plan. The plan is to give them a break at some point. It's most likely appropriate after the rebuttal argument and before the instructions. That seems to be the most logical time for a break. Unless either side goes longer, and then I don't want to keep them much more than 2 hours without having an opportunity to go to the restroom. I hate to do it, though, in the middle of your rebuttal. You see what I'm saying? If she takes 30, he takes an hour, we're an hour and 30. And if you take an hour, I just can't do that. I have to break in the middle of your rebuttal. It's like you all know the ground rules. I don't like to surprise anybody. You go longer. I don't have a big hook up here where I'm going to pull anybody off. But I will tell them that each side has instructed me that their closings are approximately an hour. Is that all right, State? I know you said hour and 15. I can say an hour to hour and 15. So that if either side goes 2 hours, they know that you told me that it was going to be an hour to hour and 15. Kind of keeps people honest on their estimates. So I just wanted to be all out there as to what break. The other thing I tell them, I've told them before, they need to take a break. So don't be surprised if one of them raises their hand, says they need a break. I'm going to take a break. All right, take a few moments, and we'll come back and we'll do closing arguments. Very much. All right, I have my stack here. You should have been provided the stack of the changed instructions. You will have time, as I indicated before, I read them to the jury, so you'll have more time. But I do want to, now that it is 10 minutes to 11, go ahead and get started with closing arguments. So I'm going to bring them in. I suspect that they're all here. I'm turning to the instruction that I'm going to give them, which I believe is 2.7. Let me just... Yes, 2.7, page 13 of 58. I will read them, and then I will turn to the state. Mr. Summers, once the state has finished their first part of closing argument, I will turn to you, and then once you've finished, I will turn back to the state for their rebuttal argument. Any questions?
Mayor.
State?
Nothing.
Anything?
No.
Let's get the jury. Oh, sign the lunch. Are we getting them lunch from the counter again?
I think we have to one day.
Will now present their final arguments. I'm just gonna, on the fly here, change that to the parties will now present. Any objection, Mr. Summers? If you're looking at 2.7, it says the attorneys now will present their final arguments, but I'm gonna just say the parties.
No problem.
Ms. Johnson? All right. Jury is present and seated. Everyone else may be seated at this time. Gentlemen of the jury, welcome back. First and foremost, I do apologize. It took a little longer than I expected. I take full responsibility for that. Do not hold that against the parties at all. You will see after the instructions and after the closings, and I give the instructions that they are lengthy, and that's what took a while to. I needed to make sure that they were all appropriate and correct. So we are though now at the stage of closing argument, and I have one very brief instruction before the closing arguments. The parties now will present their final arguments. Please remember that what the parties say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defendant has given his closing argument. State ready to proceed?
Yes, Your Honor.
All right, Ms. O'Connor, you may proceed.
May it please the court, Mr. Summers, co-counsel, gentlemen of the jury, a nightmare that Elisa Mathewson has had to relive for 5 years now, to relive in front of you, testifying here during this trial, relive the traumatic events that she was forced to endure by that man, the defendant. What this comes down to is a scorned lover. The defendant was not willing to come to grips with his divorce with his ex-wife. If he couldn't have her, then no one could. And that is what leads us to what happened March 11th through March 13th of 2017. The judge is going to instruct you, and you will get a copy of these in regards to the charges. In order for the state to prove the crime of attempted murder in the first degree premeditated, the state has to prove to you these 3 elements. Trevor Stephen Summers did some act intended to cause the death of Elisa Summers that went beyond just thinking or talking about it. Number 2, Trevor Stephen Summers acted with a premeditated design to kill. And then number 3, the act would have resulted in the death except someone prevented him from killing her or he failed to do so. You're also going to receive an instruction for aggravation of the attempted first-degree murder with the use of a weapon. The facts are clear. You heard from Ms. Mathewson after the second act of sexual battery against her by the defendant, he makes her shower. He then has her get back onto the bed. He leaves the room. He's gone for some time. She can't say how much time, but he's gone for some amount of time. And then he comes back in and, quoting Ms. Mathewson, "All I saw was an expression of evil and hatred. And at that time, I thought he's here to kill me. I'm going to die." And as she sees that look on his face, she notices he has something he is hiding behind his back. He then comes over to her as she is on the bed, tied up, and puts the pillow over her face. She starts struggling. So what does he do? He then gets on top of her, straddling her, applying more pressure to that pillow, to the point where she is thinking to herself, she knew where she was going. She was going to meet Jesus. And then she loses consciousness. And we know he did this Because he admitted to that to Sergeant Remia in his post-Miranda statement. And we know that he stopped and took the pillow off of her. Otherwise, we would be here for a different case. There was no heat of passion. One of the additional instructions as far as the attempted murder is that you will see that it is not a heat of passion. This is not a heat of passion. He knew exactly what he was going to do when he went into her room while she was tied to the bed. Keep in mind, this was hours after he had snuck into her house, shortly after 12:30 that morning. Hours after he had lingered in her home for several hours before waking her up in the middle of the night. After numerous times where he ties her up with rope, Christmas tree lights, a vacuum cord, there was no heat of passion. As to count 2, for the attempted murder, this was from March 13th, where they get to Little Harbor. He parks by a dumpster near the Hooks restaurant. We heard testimony from Ms. Mathewson that he is in the driver's seat. The defendant says that he needs to write a letter to his parents. So what does he do? He climbs into the 3rd row, gets directly behind her, who's in the 2nd row, and keep in mind, at this time, she's tied up. She showed you, she's tied up with the rope around her body with her hands up in a clenched fist-like fashion up around her chin.
Hey, freaks, we're an hour 35 minutes in, 2 hours and 20 minutes left. If you can help support the goal on the channel, that'd be great. No, there's still another 2 hours and 20 minutes, so if she does the closing, then let's see, what's next after that? I think they go there. I think there's 3, a rebuttal closing as well. So, you know, Trevor goes up next, and then the other attorney does the rebuttal closing. And then I think there was like this massive pause that I removed for hours, and then a verdict at the end. Then I think there's one more day of sentencing, something like that. All right, but if you're out there and you can help support the channel and afford it, please help reach the goal so we can continue to do these daytime trials.
Write a letter to his parents. Why go to the 3rd row? Submit to you. We all know that that's not why he was going to the 3rd row. He had already written all the letters. You had heard testimony from Ms. Mathewson that that happened well before they were at Little Harbor. He went to that 3rd row with the intent of pulling that rope and strangling her. State's Exhibit F5. We see the rope that was tied around Miss Mathewson's arm, that was used to tie around her body, and the rope that was then used to strangle her. Looking at State's Exhibit F6, this is a close-up of the rope tied to her arm. And then if you go back and look at the photographs that were taken by crime scene at her house, Miss Mathewson's house, the rope that was found in the trash can, and this is in State's Exhibit Set 1, A38, we see the black rope in the trash can. The exact same rope. The rope that you heard Miss Mathewson say she saw him pull from his pants pockets the early morning of March 11th of 2017. He went to her house with this rope. Why would you go to your ex-wife's house with rope if all you're doing is intending to talk? State's Exhibit K3 shows you the linear line on Miss Mathewson's neck, on the left side of her neck, and K4 showing how that line goes around to the back side of her neck. And those are the photographs and observations that Ms. Hall, an advanced registered nurse practitioner who conducted the sexual assault exam, as you heard testify, observed on Ms. Mathewson. And you heard Ms. Hall say that these types of marks can take up to 24 hours to appear. So while you may see it on the left side at the time in which she did the exam, it's possible that there could still be some marks appearing on the right side of Ms. Mathewson's neck based on the strangulation with the rope. You also heard the testimony from Ms. Hall that the linear line is consistent with that coming from a rope. And what else did she say? That it had to have been applied with enough pressure to leave that mark. Again, this was no heat of passion. This was premeditated. He had no intention of them leaving that vehicle at Little Harbor. By the grace of God, what he thought to be an undercover vehicle drove by, and he got scared. He failed to follow through with what he intended to do for a second time. As to count 3, we have the kidnapping incident from the Walgreens. Go back, listen to that 911 call from Mr. Crosby, Exhibit C. Consistent with what he testified to here the other day. We heard testimony that once they get to the Walgreens, the defendant parks the car away from the store. He goes into the store. Remember, her hands are tied behind her back. And she still had that blanket over her shoulders that he put on before leaving the house. She's somehow able to move her arms a certain way to unbuckle herself and then open the door and get out and try and run. And she told you she ran to the main road because she knew she couldn't go in the store. That's where he was at. Hopefully thinking that somebody driving would help her. Unfortunately, the defendant saw her running out of the car, and she wasn't fast enough. You heard Miss Mathewson testify that he grabbed her, picked her up, forced her back into the passenger seat as she is struggling and fighting to keep him from putting her back in there, because she knew. She knew what was going to happen if he was able to get her back in that car. And then he drives off. You heard her testimony that she was able to get the door open one more time as they're driving. He stops the car, then buckles her up, ties her, and slits her wrist, saying that's for trying to run away. The defendant admitted to Sergeant Remia that she ran. He went out after her, grabbed her, put her back in the car. He even admitted that her hands were still tied behind her back. And then he tied her to the seat. He goes on to describe how from there, because now most likely the authorities are going to be contacted, that there's no way they're going to be able to go to his house and say goodbye to the children. So he drives for several days through Manatee County and Hillsborough County. In the kidnapping instruction, you will see for element number 3, the state has to prove the act was committed with the intent to commit or facilitate the commission of a grand theft of a motor vehicle. And that is in count number 10 as a separate charge. And the state submits to you that the grand theft motor vehicle started when they left the house before going to the Walgreens, because we know her hands are tied behind her back. We know she's not the one driving her vehicle. We know the defendant is the one who took the keys, puts her in the back seat, and drives. We also know from his own statements, again, that he is the one who drove throughout Hillsborough County and Manatee County for the next few days, throughout the 11th, the 12th, and the 13th. At no point in time did Ms. Mathewson ever drive her own vehicle during those 2.5 days. One of the elements as far as the grand theft motor vehicle that you will see is that the defendant knowingly and unlawfully obtained or used or endeavored to obtain or use the motor vehicle. Well, we know he was using it. He didn't have permission to do so. And temporarily or permanently deprive. 2.5 days where she doesn't have access to her own vehicle. Several times throughout, she is tied either to the car, the captain's chair in the car, or tied herself. The state submits to you that the kidnapping facilitated the theft of her motor vehicle. Now, as to counts 4 and 5, the sexual battery, the state's required to prove to you 4 elements. And I submit that elements numbers 1, 3, and 4, those are not at issue here. We know that the defendant, per his own statement, had sex, according to him, with Ms. Mathewson, and that his penis penetrated her vagina. We know that they're both over 18. The issue is element number 2, consent. So let's look at the definition of consent. It means intelligent, knowing, and voluntary consent, and does not include coerced submission. Consent does not mean the failure by the alleged victim to offer physical resistance to the offender. The state does not have to prove to you she tried to fight him off. The state does not have to prove to you that she said no. You broke into my home in the middle of the night when I was sleeping, attacked me, and tied me up. I call that rape. Miss Mathewson's words just the other day. That's exactly what it was. She felt that she had no other option. And I want you all to go back and pay close attention to the defendant's post-Miranda interview, because every other time the defendant talks about having sex, he describes it as sex. We had sex. We had sex. Pay close attention around the 15-minute mark when he describes the sex that occurred on March 11th of 2017. He says, and then we had sex 4 times, consensual. It wasn't forced, nothing, completely consensual. The one and only time that he described it as being consensual. Why is that? Counts 6 through 9 is the child neglect of the children. And I'm not going to put up all of the instructions because they are all the same. It'll just have the different initials for the children. But the state is required to prove to you 3 elements. That the defendant willfully or by culpable negligence failed or omitted to provide the child, in this case, this is going to be for Arden Summers, with the care, supervision, and services necessary to maintain Arden Summers' physical or mental health. He was a caregiver, and then at the time, Arden was under the age of 18. There's no disputing this at all. We know for a fact he let his 14-year-old daughter drive home, about a 26-minute drive, from Miss Mathewson's house to his house around 6 o'clock in the morning. You heard from from Arden Summers, she didn't even know where she was going. Luckily, she knew how to use the navigation system in the van. And then, once all the kids are home, there's no adult. You have Arden and her other siblings, Bryn, Grady, Landon, and Cooper, all home until about 3 a.m. on March 12th, when law enforcement knocks on the door of Carol and Stephen Summers, asking one of them to go over to the house because there's no adult. And prior to even Arden arriving back at the house with her siblings, we know that the defendant had left the youngest child, Cooper, who was 3, at home, all alone, because he was asleep. As to count 11, we have the violation of the DV injunction, the domestic violence injunction. Again, there is nothing in dispute with this count. The interview the defendant provided to Sergeant Remia, the video that the defendant made on Miss Matthewson's phone, which is Exhibit Y. And we have the order of the injunction in service on him, which was Exhibit AA. So, the evidence that you received in this trial is overwhelming. But all of it, the 911 call that was made by Mr. Crosby, the Walgreens video, the text messages that were between Arden, Landon, and the defendant, the videos the defendant made, the confession letter he wrote, the letter he wrote to his kids, states Exhibit S3. Where he says, "We wish you the best in everything you do, and we'll be watching you from heaven." His own statements to Sergeant Remia. The testimony from Deputy Cruz of Miss Matthewson when he was able to extract her from that vehicle, the sense of relief on her face, how frantic she was, how upset she was. Of course. The ordeal that she had went through, and the relief was because she knew if nobody had found her, she would be dead. I want to talk a little bit more about the defendant's post-Miranda statement to Sergeant Remia, as there are additional statements he made other than what I have already discussed with you, contradictory to what the defendant claimed. This is not a situation where you have two individuals who are quarreling over a divorce. His comments to Sergeant Remia about how it messed up his mind, she was messing with his head, is nothing more than, again, him not wanting to accept the fact that their marriage was over. There were no mental issues or health issues that the defendant was having. This is not an insanity case. You will not get an instruction on that. And that is not something that you should consider. There is nothing wrong with him mentally. He just could not get over the fact that she began dating. And according to him, was lying about it. And that's what made him upset. Gentlemen of the jury, shortly after 12 a.m. on March 11th, 2017, when the defendant snuck into Ms. Matthewson's house in a window on the side of the house, not through the front, on the side, he did not have the intention of just talking. You don't sneak into somebody's house in the middle of the night with the intention of just talking. I submit to you, he also never had any intention of either of them getting on a boat and going to the islands. His intentions were for her at first never to leave that house. And then when that didn't work out, to never leave that car at Little Harbor. The state has presented to you an abundant amount of evidence that proves beyond a reasonable doubt the charges in which he has been charged with.
Mr. Summers?
Thank you. Good afternoon, gentlemen. Good afternoon, Your Honor. Good morning, Your Honor. Good morning, gentlemen. Good morning, State. I'd like to just be able to share with you a re-representation of what we've heard over the last week. And I'd like to start with just helping you understand from the details that were given and consider that the condition of both myself and Mrs. Mathewson were not adequate enough to truly paint a picture that you can understand. If you recall, we spent a lot of time that weekend just talking, just trying to figure things out, wrestling around, fighting about a variety of issues. Some of them you heard about, some of them you haven't. But you do remember that we didn't sleep very much. Our emotions were all over the place. Our stress was high. You've heard these things through her testimony and through statements of others in this case. And so I ask you to please keep that in mind as you look through, as I walk you through the facts that were presented. I first ask you to pay attention to the photographs. As you walk through the photographs, I ask you to please look through them and notice things in the residence of Mrs. Mathewson. That there were no signs of a struggle. That there was not broken glass or dents in walls. There's not scratches on countertops or blood splatter. This was not a scene that depicted some kind of crime or some kind of anything more than what she described as wrestling around. And I also ask you to look and see that the things aren't thrown about as she described. Things are where they're supposed to be. You can see that we packed, we left, and we had a plan to go to my house. Her accusation is that she was tied to go to my house. But I ask you, does it make sense to go meet children with a woman tied up? I also ask you to look at the items that were disturbed by law enforcement during their 3 times investigating that home. There are a number of things, statements that were made, including a variety of articles within the home that weren't brought in front of you, so that you can't make conclusions, so that you can't corroborate the stories or the statements that were made here. I also ask you to look through the pictures of the vehicle. I ask you to consider that they don't line up with her stories either. Little things like the pancake platter sitting in the second row and not the third. Little things like a purse being full of all kinds of contents that were helpful to her, useful to her, that she didn't really need if the whole intent to take her somewhere and kidnap her or steal her car. Why would she need her purse? Why would she need her phone? Why would she need her charger? It doesn't make any sense. And I also ask you to look at the car handle. The car handle's far up in the front of the door. And her statement is her hands are tied behind her back. I think most of us understand that if you lean your back against the car door and you pull the handle, you're going to fall out. You're going to tumble on your head. But she didn't say that happened. I also ask you to look at the pictures of Mrs. Mathewson. You'll see the full pictures when she was evaluated and examined after these events. You'll see that the bruises line up with wrestling around. You'll also see marks of bruises on her arms where she said, I lifted her up through a ravine. And you'll see exactly that's true. We pulled her up through a ravine. You'll see that there are blisters on her heels. Again, I mentioned to you guys, or I questioned her about why she didn't put flip-flops on, why she would put shoes back on if she already had marks on her heels. And her answer is non-responsive. And so...
Objection, Judge. Inappropriate misstatement of the facts.
Well, I'll instruct the jury this time if what Mr. Summers says during closing and the attorneys during their closing is not evidence in the case. I will instruct you to rely on your own recollection of what the testimony and evidence was.
If you remember, we walked through those fields for hours in muddy conditions. Those shoes, as Ms. Mathewson testified, were getting stuck in the mud, and clearly that's what caused the blisters on her heels. You won't see any kind of rope burns on her wrists or her ankles. They're not there. You also won't find any photographs of anything after that. The law enforcement failed to investigate anything further beyond Ms. Mathewson's condition to see if another bruise would show up on the other side of her neck, or if any bruises or marks would show up anywhere else. That would have probably been a normal thing to do. And you'll also see that we physically fought each other. I don't argue that with you. And I also ask you to look at the photos of Mr. Summers, of myself. You'll see that I was in no condition to be interviewed by the police. You'll also see that if you were in that position, you would feel vulnerable. You feel taken advantage of. You see that I was restricted, I was captive, and possibly coerced. And I argued that. Aside from the pictures, gentlemen, I ask you to look at the videos. If you look at me at Ms. Summers' house, I'm in a confused state of mind. We're going through a divorce. We don't know what's going on. I questioned Ms. Mathewson about our conversations about her pregnancy, and she recalled some things that we had talked about. This was something that I want you to consider. I also want you to consider a very special moment in that video where I'm asking Ms. Mathewson what else she would like me to say. I submit to you guys that when you're in these kind of positions, you can clearly see through the complexity of this evidence and through the variety of it, how the emotions are all over the place. I also ask you to look at the Walgreens videos. Mrs. Summers goes into, or Mr. Summers, myself, I go into the store, but that's the opposite of the state's witness. He doesn't see me go into the store. He doesn't even know where I came from. That's his testimony to you guys. He doesn't know what kind of clothes I'm wearing. He doesn't know what kind of clothes she's wearing. But this is the main witness that's supposed to identify that the one single thing that he saw was her hands behind her back. He said her hands were behind her back. And I don't know how she ran out of the car. But were they tied? You have to make this decision. Again, I point to you, how do you get out of the car, your hands tied behind your back, and open the door and not fall out? I also ask you to look at that Walgreens video and see that it was parked right in front of the store. If someone's held captive in the car, I don't think it's logical that you would park right in front of the store. I think you would park somewhere where no one else might see that. I think you would probably park in a different way so that if you needed to, you could get out quickly. But the testimony was that the vehicle was pulled directly in front of the store, head first into the parking spot. I also ask you to consider looking at the vehicle not speeding away. There was no rush to leave there. It wasn't that much of a concern. It was a moment of panic. As you also look at the other videos, please look at the McDonald's video. Mrs. Mathewson was free to leave. It was a perfect opportunity. If this is true, if all this weekend, after 50 hours, all of these things were true, what better opportunity than there for her to leave? She had the opportunity to order what she wanted. She was not being held by myself at all. Now, I know the video played with a little bit of choppiness earlier. I ask you to watch it again and see if you can get it to play smoothly and see that, no, this is a agreed upon situation. We're in there together. We're getting breakfast. We're moving on. I also see that, she is cooperative with me. She's using her purse. She has the contents of that purse. And there's no issue that whole time, almost 2 minutes, maybe even more, of going through that drive-through. Logically, I would not be able to get out of that vehicle. I had a seatbelt on, and my door would immediately hit the building. And again, a great opportunity for her to leave. As you look at the Sitco video, there are 3 videos on there. 2 of them show me inside the store. One is from a different angle, where you can see that the vehicle is not parked at the first pump. I ask you to look at that. Ms. Mathewson states that I pulled as close to the store as possible and right next to the first pump. That's not true. I didn't have any concern about where I had to pull, close in proximity to the store. You can see that from her vehicle where her gas tank is and where you have to pull into the gas station. It's just logic sense. You can also see that I was there inside the store for a number of minutes, and then again, another opportunity for her to just walk away, run away. I remind you guys that this is 6:50 in the morning on a Monday morning. There's people all over the place. It's rush hour.
Objection, Judge. Facts not in evidence.
I will instruct the jury, again, that anything that Mr. Summers or the attorneys for the state say is not evidence, to rely on your own recollection as to what the evidence was in this case and testimony that came from the witness stand. I will instruct you, Mr. Summers, to avoid arguing things at this time that are not in evidence.
Okay. I'm just remind you that I showed the time on the receipt of the McDonald's slip, and that it was a Monday, and it was just before 7 a.m. Also, then ask you to consider the testimonies of the people given. The first is Randall Crosby. Again, he does not recall where I came from. He does not recall what clothes I was wearing, what clothes she was wearing. His statement is pretty inaccurate. He doesn't recall what vehicle it was that was 15 feet from him, even though the name and the insignia is right on the back of it. Only he was focused on was getting that license plate. He was paying attention to that, not what was happening with us. I don't understand how he could be able to look at the vehicle and get the license plate at the same time pay attention to what we're doing. He was also on the opposite side of the vehicle in orientation. He's standing by a red box machine. As you look through the videos, as you look at the overall of that store, you'll see that his position was not a very good view of our position, of Mrs. Mathewson running away, of my position coming out after her. He did not chase us. He did not follow us. He was also the only person standing outside at that time. You'll see a few other people walk into the store a little bit later. All of these people were also available to Mrs. Mathewson to go and talk to. If I'm in the store, she could have went and talked to him or tried to seek help from him. He also, in his 911 call, you can listen to that, it says that he didn't even know the street location of where he was working. He didn't know that the place of his employment in his testimony, or what time he started the shift, what time he ended. He was also not close enough to hear the things that were being yelled at each other. Mrs. Matheson said that she yelled. We were screaming at each other as we were going back to the car, but he couldn't hear that. I then point to you to Kimberly Shea, who gave you a very accurate evaluation of what she saw. Her statement was true. She was pulled in directly across from the passenger side of that vehicle. She saw the emotion on Mrs. Matheson's face. She saw that we were in some kind of an argument, some kind of a torment. And she also saw Mrs. Matheson's hand. She saw her hand leaning on the door sill and leaning up against her face. That wouldn't indicate that her hands were tied at all. I also point you to Ms. Shea's knowledge of the exact type of vehicle it was from the moment that she saw it, color, the position, how far she was exactly from the vehicle, and that we left. Then we go to David Chesla, Dr. Chesla. Dr. Chesla did not operate on me as he stated. He also doesn't remember even seeing me. He could not tell exactly what time and what type of medications were given to me. He's only assuming from some records that he may or may not have been involved with. He doesn't know what the volume of the doses were or what types of medications could have had. He didn't testify to what kind of impact those combinations of medicines could have had. He did not speak with law enforcement, and his responses were quite vague. Then to the other medical professionals that testified. Teresa Wagner, Rita Hall, and Francesca O'Neill. They were all involved in some kind of DNA analysis or some kind of evaluation of Mrs. Matheson's injuries and the sexual battery kit. And again, that sexual battery kit, the test came back, no evidence of rape pointing to me, no DNA matched to me. And this happened immediately after the alleged sexual encounters. This didn't happen after Ms. Matheson showered. Her allegation is that this happened on Sunday, and this test happened, and the rape test was given to her on Monday. They also tested the clothing from Mrs. Matheson, and none of that tested positive for myself being in contact sexually with Ms. Matheson. The sheet from the bed tested positive for my DNA, which the analyst said could have been there that day or sometime prior to that. You know from Mrs. Matheson's testimony, we were in contact prior to the 11th of March. I also ask you to consider the testimonies given by law enforcement. They were not a witness to anything prior to the simple, peaceful arrest. I did not resist. I did not see, not have any testimony of me causing any problems or acting in any kind of irrational way with them when I was arrested. They did not attempt to investigate, despite all of this available DNA, fingerprint analysis, things that could have corroborated the story, maybe made it a lot more sense for you. But they did not attempt to test the pillows to say, yes, this is evidence of her accusation. They did not attempt to test the Christmas lights to see if there's any trace, as the fingerprint expert testified to see if there's anything on the glass bulbs or any kind of skin, any kind of anything with these Christmas lights. They did not attempt to test all of those items in the vehicle. I asked Mr. Becker, could this have been tested? Could this have been tested? And it was their position that, yes, it could have been tested. And if you think about it, think about all the things, and you look through those pictures, look at all the things that were in those vehicles and line them up with Ms. Matheson's testimony and see, would those things have some value? I believe you would find that to be true. I also believe that the contents in the trash can, the rope, they collected it, but it was not tested to see if there were any kind of skin or DNA evidence on that rope. That probably would have been a good thing to do. They did not check the NyQuil bottle, the other bottles, the broken wine glass. Look at all these things. They did not check to see if any of those produced any kind of evidence that would corroborate the allegations against me. So you have to ask yourself, is that reasonable? Is that fair? They also did not check anything about this statement that they collected from me in a hospital that was taken after, again, you know that high dosage of medication was given to me. They did not check to see if there were boat charters on any kind of schedule or any kind of thing that could have even corroborated my story there. They did not check to see if I had offshore accounts. They did not check to see if any of these directions that I'm giving. If you listen to that interview, I'm talking about this road and that road. Maybe you guys are familiar with the area. Maybe you know.
Objection, Judge.
I will instruct Mr. Trevor not to place the jury in your shoes or the shoes of any party. Don't make arguments like that where you to the jury.
Okay.
You can argue the facts. but avoid what you just did.
Gentlemen, I would just assert that the law enforcement did not check to see if these directions even fit to a map. And they also didn't seem to think that the statement about immigrants was a little bit out of whack. I encourage you to listen to that video or that audio of this interview and see if someone really does sound like they make sense, or if they sound like something different, in fear, in panic, concerned. Look at the condition that I'm in, look at the medication given, and please draw a conclusion from that. I also submit to you that law enforcement failed to recognize any red flags or false statements regarding if I owned a house and if I was able to just sign it over to somebody. If I owned a car, I'm just able to sign it over to somebody. Or even if the passwords to the bank accounts were valid or not. These all would have been important for you to make a decision about whether or not I was giving correct information. The police also purposely did not interview me when I was awake, sober, clear-headed, or recovered. They only interviewed me one time at a hospital where I was vulnerable. That's it. There's no other time. They didn't come and ask me later if I could please explain things better to them. They didn't come with a written statement, ask me to sign it. They didn't try to attempt to get any other information from me. They thought, case closed, he said what he said, and that's it. I also submit to you that the law enforcement made no attempt to follow up on the marks on either side of Mrs. Matheson's neck. Again, they took some basic statements and said, it's been a long weekend, we're just going to conclude here. Law enforcement also could have taken more items into evidence to fill the holes in the story and to corroborate this story. And I believe that would have been much more helpful for you to make a decision in this matter. Then we turn to the children. They only said a few things. I didn't ask them much. I didn't believe they even said too much of value, but the little bit that they did say, it contradicted their mother being dragged down a hall in the house. It contradicted what their mother said about being restrained in the corner of the living room. It also shows that mother had no interest in speaking to them when the oldest Arden came into the home, while the youngest two were into there. There was no information given to them. There was no concern to them about while Mrs. Matthews and I are arguing and fighting in the home. And then we turn to the statements of Mrs. Matthews. These statements were outrageous. The statements were exaggerated. The statements were, most of them, impossible. Responses to simple questions were abrupt and over the top. The calm answers, if you recall, they revealed some truths, such as wrestling in the living room. That's a true statement. Such as sleeping in the car. That's true. Such as not caring about sex. That's true too. Such as just calling it sex. That's true. About being woken up by water droplets rather than some other crazy way. If you guys remember the timeline that was presented, they say that I came to her house at 12:30 in the morning. And she finally woke up around 3. Text message showed between me and my children. I'm trying to wake her up. Showed that I tried to turn on television loud. I tried to put lights on and off. Tried to slam some doors. I think you guys can understand that. I also ask you to pay attention to the statements that Ms. Matheson made. She drove to my neighborhood after these prior allegations. She said nothing to her children to help her in this alleged situation. She was already in the bedroom, and she made no statement of being drugged back into there. She claims an entire bundle of rope fit in my jeans pocket. That rope, again, was not tested to see if used in any allegations here. She claims that there was a sock in her mouth, but does not recall those details. And as you go through the evidence, you'll see that no sock was recovered. You'll see that no sock was tested to corroborate this claim. She claims that duct tape was on the mouth, but again, nothing corroborates this. You have a picture of duct tape. You have a very simple thing that law enforcement could have tested and said, yeah, what she said is true. Press start here. You also have a statement about predominantly calling it sex, and then has a cigarette after each time. She offers no details like in the other accusations. We just had sex and we move on. She also says that she was screaming when she came back to the vehicle at Walgreens. Again, no witness made this kind of observation. She says that she opened her car door with her back to it and did not tumble out on the ground. She says that she refuses to recall the majority of the time we were together over the weekend. If you recall, we were together roughly 30 hours apart in the country, in the woods. but she can't remember most of the conversations that we had. She also says that we were driving around on Monday morning between the hours of 6 a.m. and 10 a.m. on some very busy roads. But she made no effort to signal another car or really elaborate on any of that time for you. She also states that we argued throughout the weekend, and that should truly help you understanding the range of emotions that were happening, the things that were happening in a divorce situation.
Objection, Judge. Facts, not evidence.
Again, I'll instruct the jury to rely on their own recollection of the facts were. I'll caution Mr. Summers to please avoid arguing or referring to any facts that were not testified to in this case.
Yes, then we'll go to my interview. If you evaluate me on this statement made in the hospital, I hope you find that it doesn't make much sense. I hope you find that there are a glaring number of issues, sometimes in, sometimes out. Things about, again, boats and incongruent driving directions, about immigrants, about a variety of things that really show a concern for the situation I'm in. So please evaluate that based on the conditions that you know surround that interview. Aside from this, gentlemen, I just remind you that from the beginning, I've assumed my presumption of innocence, and I maintain this until now. I assert that the state has not proven what was in my heart, especially regarding 2 counts of
Objection, Judge. Inappropriate requirement of the state to prove what's in its heart.
I'll instruct the jury that what Mr. Summers say is certainly not the law. In this case, the law will come from me, and the elements of the crimes will be contained in that law. Mr. Summers, restrict your argument to the law and the evidence in this case, please.
Yes, sir. I'll rephrase that, gentlemen. The state has not proved my intentions. They have not proved that I intended in counts 1 and 2 to kill Mrs. Patterson. In my statement in the hospital interview, I clearly never said I intended to hurt her. If you're relying on that, that's fine. I never said I intended to kill her with a pillow, and I never said anything about the rope. Never mentioned the incident one bit. I'm also going to assert that they did not show any intent to steal a car. They did not show that that was the underlying reason that Mrs. Mathewson went with me. They did not show that I intended to kidnap her. There's a lot of holes in their story, and I ask you to please consider that when evaluating whether or not you find the facts true. They also did not show my intent to take advantage of Ms. Mathewson in any sexual way. You've heard the way I've described it in my interview. You've heard the way she's described it, and I hope you can appreciate that. I also believe that you would find that they did not prove that I intended to steal a car, which is one of the later charges on this long list that they've put together. I believe you would find that it's a civil matter, and that when 2 people are married, they commonly use each other's vehicles, even if they are separate.
Objection, Judge. Improper argument.
Again, I'll instruct Mr. Summers to limit your argument to the facts and the law that are applicable to this case.
I assert that utilizing cars while married is a civil matter. I also don't argue other issues. I ask you to just be favorable in understanding my position here. I ask you to please be cautious in understanding what burden of proof the state has to provide and how high that threshold is. That you cannot have doubts about these allegations. They are very serious.
Objection, Judge. Misstatement of the law.
I would instruct the jury that, again, what Mr. Summers says is not the law. You will hear the definition of reasonable doubt when I instruct you on that law.
And so, gentlemen, reasonable doubt, I believe, is everywhere. And I ask you to please remember that and to please focus on that element that has to be proven by the time that you make these decisions about my life, about the situation that you've been presented, about deciding whether or not to find me innocent or guilty. I ask you to please consider all of these factors and see that what I am trying to show you is that this was a very abnormal series of events, and it requires a lot more information for you to draw a conclusion that would say that I absolutely am guilty of these crimes. And so for all of these reasons, gentlemen, I thank you for your time. I thank you for giving me the opportunity to explain this to you and to share with you a better understanding of putting it together. I thank you for allowing me to paint a little bit better of a picture, and I do appreciate your time, and I value your opinion on this. And I do ask you to please find me innocent of the charges against me, and to consider what else may be available to you as you are instructed by the judge. Thank you. Thank you, gentlemen.
Ms. Johnson, rebuttal from the state.
May it please the court, Mr. Summers, co-counsel, members of the jury.
Okay, Art and Landon, I need to give you guys some information, and I want you to make sure you understand this. I spent a lot of time with Mom the last few hours, and the things that she's told you about me being good at manipulation, control, and lying is true. And tying her up.
That is Trevor Summers in a nutshell. Manipulative, lying, controlling. And Elisa Mathewson finally had the opportunity to stand up to him on that witness stand this week. She finally got the opportunity to stand up for herself and tell you exactly what happened on March 11th, March 12th, and March 13th. The defendant chose to represent himself, and that you have a special instruction in which to consider that. You are not to base your decision because you feel sorry for him, because you dislike him, or because you like him. You are to base your decision upon the law and the facts and evidence that have been introduced during this trial. The same goes for any witness that took the witness stand and the attorneys in this case. You must not make any decision in this case because you like or dislike anyone. It must be based solely upon the evidence and the law and the facts in this case. I'm going to touch upon some arguments made by the defendant a few moments ago. He said that there were no dents, no glass broken, no blood at the home. Did Miss Mathewson ever describe the incident of her being pulled from the bed by her feet and taken into the family room? Did she ever describe it in a manner that you would expect to find broken glass, blood, dents in the walls? No. She described it that he pulled her from the bed from her feet. She was throwing items at him, and then he guided her out into the family room, and she kept trying to get up and try to run out that door. That's what she told you. So I would submit to you that the photographs that were taken on March 12th of 2017 of her home clearly depict what had occurred. They corroborate what she told you had occurred in that family room. We see the pillows nicely aligned on the sofa that she was laying on earlier that night watching the Storks movie with Brennan Grady. The pillows are put on the couch in a neatly fashion. Look at the photograph of the way the pillows are on the couch that she tells you that she kept trying to run from the defendant on. They're all on the ground. He says, look at the fact that the cup and the Kleenex aren't where they were. She said she threw them. What do we know about what happened in that room? We know Brennan Grady were in that room after they were told to go back in the room, after the defendant told them to go back in that room and not come out. We know they were in there for some time, worried about their mom, yelling to their mom, "Are you okay, Mom?" And she yells back, "Everything's fine." Could they have picked up the cup and put it on the countertop, picked up the Kleenex box? We know that Miss Mathewson and the defendant were in that room for hours on the 11th. Is it unreasonable to think at some point when he walked in the room to tie her up multiple times, he picked it up, picked the Kleenex box up? No. He said that she was not tied when he went to Walgreens. Why would he take his estranged wife to go see the children for one last time tied up? The problem with him making that argument is that in his recorded post-Miranda interview, he says that he tied her up. So he's arguing moments ago that he didn't tie her up to go to Walgreens, yet in his post-Miranda admission, he told the law enforcement officers he tied her up. He said, I said, should I at least tie your hand so you don't do anything dumb in the car? He tied her up. Talks about the blisters, the blisters that, why would she go walking in this area, or this area was high brush, high dense area, and that's how she got those blisters. And then he was like, well, why didn't you wear flip-flops if you already had the blisters from being tied up? And she explained, he said they were out in the woods. She described this as a high, densely brush area. And she was not going to wear flip-flops to walk through this, on this journey that he was going to make her go on to go find water. Is that unreasonable? He says in the video that he made that he was being nice and asking her what else he should include in that video. You don't see her in that video. She's not a happy woman who just had sex with the love of her life, wrapping her arms around his shoulders on that video. She's hogtied, laying down. That's why you don't see her in that video. He talks about the Walgreens video. He wants you to go back and watch that video. I'd recommend that you go back and watch it, because what you're going to see is you see him walking into the store. He goes out of camera for a minute. He comes back in the angle of the camera looking out into the parking lot. And soon thereafter, he realizes that Miss Mathewson had managed to escape from the car while tied up. And he walks out of the store, and if you keep watching the video, he then proceeds to start running after her. And Mr. Crosby testified that he saw the defendant come from the store running to Miss Mathewson. Grabs her. That's how Mr. Crosby describes the interaction. Grabs her and takes her back to the car after she was yelling, please help, call the police. If that's not kidnapping, what is? Why would he park in front of the store if he had tied her up and she was going with him unwillingly? You heard Miss Mathewson explain over and over again. She was with him for 16 years. She placated for him. She did what she had to do, so there was not conflict. She did what she had to do on March 11th, 12th, and 13th to stay alive. She was staying on his good side. She was going to do what she needed to do to make sure she stayed alive. That's exactly what she was doing this entire time. And it was finally on the witness stand this week that she was not going to placate him anymore. She was not going to go along with what he said. And she stood up for herself. The McDonald's video is a classic example of what their marriage was for 16 years, of her going along with what he said. He had threatened her before they went through the drive-thru, if you do anything, I'm going to hurt you. So what did she do? She did what she had done the last 16 years and just went along. She knew she had to do that to stay alive. He argues to you, if she could have gotten out of the car, I wouldn't have been able to get out of the car. My door would have hit the building. He was in the car. He could have run her over with the car. He had already tried to suffocate her one time. What would stop him from stepping on that pedal and running right into her if she tried to flee? She tried to flee one time. Remember, she tried to flee on March 11th at the Walgreens. She tried, and she was unsuccessful. So she knew from that point on, she had to just go along with what he said until there was another opportunity, or until she was going to be able to convince him to let her go. Watch the Sitco video again. What did she tell you about what happened when they were at the Sitco? She was required to go back to the third row because he knew that the last time he left her in the vehicle, she had tried to run away. So she had to go into the third row and watch the video. Watch his demeanor and his actions in that video. He couldn't grab that dip fast enough from the employer or the employee there at the Sitco. He didn't wait for his change. He goes to proceed to walk out, and then he remembers he wants to get a newspaper because why? He probably wants to find out if people are writing about what had happened. the kidnapping of Miss Mathewson because he had been listening and looking for it on the radio. So he gets the newspaper again. He doesn't even want to hand the newspaper over for the Citgo employee to scan it. The employee almost has to grab it from him to be able to scan it. He throws his money down again and he leaves. And the entire time that he is standing at the countertop, he is looking out the window for Miss Mathewson. Going back for a moment to Mr. Crosby, he says that he didn't know the make and model of the vehicle. He was more concerned about the license plate. Well, what's more important to give to law enforcement? Is it more important to get the make and the model of the vehicle or the license plate? And he is the most independent, non-biased witness in this case. And recall his testimony. He saw her with her hands tied behind, behind her back, running, yelling for help, call the police. And then the defendant, who he can identify, grabbed the victim and put her in the car. He talks about Kimberly Shea and that she described during cross-examination that she thought possibly maybe her hand was resting up on the door and that she looked distressed. And Miss Shea, 5.5 years later, the first time she's saying about the hand on the window was through the Zoom testimony, 5.5 years later. She told you she gave a very detailed written statement that included descriptions of both the male and the female, what she observed, the car. But that one statement of hers was not in that written statement. But he wants you to hold on to that so tight. But what we already know from his statement and Miss Mathewson's statement and Mr. Crosby's statement is her hands were tied. Because in the interview with Sergeant Remia, he admits that he tied her hands up so she wouldn't do anything dumb. Why would he have to tie her hands up if she had agreed to go with him? Let's talk about his interview for a minute because he keeps harping on the fact of the medication that he was provided, that Hillsborough County Sheriff's Office didn't follow proper procedure in interviewing an individual in the hospital, that his statement was not knowing and voluntarily made. The state would submit to you that that 37-minute recording speaks for itself. He was provided fentanyl at 12:18. What did Dr. Chesla tell us about fentanyl? It is fast on and fast off. It quickly relieves people of pain and it quickly wears off. We know that there were other drugs prescribed because they generally give nurses options for different pain management. But he told you that looking at the list, none of them had been given other than the fentanyl. None of the other drugs had been given to him. And listen to his recording again. He is clear. He makes sense. He does the majority of the talking. He says, this is just the cliff notes. I can provide more details if you want them. Those are his statements. He's not saying, I can't talk right now. I'm in so much pain. I don't understand the questions you are asking me. Can you come back? None of those things come out of his mouth. He could not been clear on the facts and circumstances surrounding what occurred those last 2.5 days. The DNA. There was no DNA linked to the sex battery kit of Miss Mathewson, of the defendant's DNA. Well, we know from the defendant's own statement that they had sex. The issue for you to resolve was it consensual or not? So the fact that there's no DNA there, he didn't argue to you that they didn't have sex. What does that matter? The issue with regards to the sex is whether or not it was consensual. And the state would submit to you someone who sneaks in Miss Mathewson's home in the middle of the night, ties her up, the sex was not consensual. It is not reasonable to believe that someone would consensually have sex with that man after he tied her up with scarves, rope, Christmas tree lights. And that's not all just coming from Miss Mathewson. It's his own statement. He tied her up with the Christmas tree lights. So what would the DNA results on the Christmas tree lights give you? He already tells you that he had tied her up with the Christmas tree lights. What else did we learn from the DNA from Miss Montgomery O'Neill? That If people shower, that's going to affect the DNA. If people go to the bathroom, that's going to affect the DNA. And if someone has a vasectomy, that could affect the threshold. But again, the state doesn't have to put the semen inside Miss Mathewson. He admitted in his own statement that they had sex. The issue is consent. He talks about that law enforcement did not follow up on the writings, that whether a house can be transferred via writing, that a car or bank accounts were the correct bank account numbers. The thing with that, ladies and gentlemen, the state would submit to you that he never intended for Miss Mathewson to have any of that stuff. If you look at the note to the children, that explains 100% what his intentions were. His intentions were to kill Miss Mathewson and himself. You decide what kind of letter that was. Miss Mathewson was never going to kill herself. All she wanted to do was get out of the situation alive and to be with her children. He never intended for her to ever get out of that car. So he's going to pretend like, I'm going to let you go as long as you don't call the police. And she's like, I promise you I will not call the police if you leave me these things. But he was never going to let any of that happen. So he didn't care if it was a valid quitclaim deed or a valid surrender of his parental rights, because he knew all along what he was going to do. He knew all along that he was going to kill her. And he was going to kill himself because he was going to be watching his children from heaven. That was his plan all along. He wrote those letters when they had arrived on the Anna Maria Island. They had pulled off. This is coming from Miss Mathewson and his own statement. That's when he wrote the letters. That's when he wrote the confession letter. That's when he wrote the letter of the surrender of the parental rights. That's when he wrote all of these letters, including the letter to the children. But Miss Mathewson never knew that letter to the children was written. She never saw that letter. He was never going to let her know he wrote that letter, because she would then know what the plan was. So he's driving around looking for this flag. That's what he told her. He was driving around trying to get up the courage to do what he knew he was going to do all along. He was trying to find the right place, but he didn't find the right place at Anna Maria Island. So then he moves along to Little Harbor. And that's when he had enough courage, he was going to handle it. He was going to kill her then. That's when he got in the third row and he took the rope around her neck and began to strangle her. And then he jumped in the car and fled because he saw an undercover vehicle. So these writings and the fact that law enforcement didn't follow up on them mean nothing, because to him, those writings meant nothing. He was never going to let her out of that car alive. He brought up Bryn and that her testimony contradicted Miss Mathewson's testimony. She was 7 years old when this happened. 7. What did she tell you, though? She told you that she saw scars on her dad. She told you that she was in fear for her mom. She was afraid for her. Is that contradictory of what Miss Mathewson told you? The defendant brought up the February 18 incident, and the judge read you a special instruction as to how you were to consider that evidence. And the state would submit to you that you must follow that instruction. And one of the ways that you can evaluate and consider that is to corroborate the victim. He talks about how Miss Mathewson can't remember conversations that they had for the 30 hours that they were in that car. What did she tell you? She told you that he can just talk and talk and talk about nonsense ad nauseum. Nonsense. And he tries to act like that there was this big tumultuous arguing happening over these 30 hours. That's not what Miss Mathewson told you. She was playing along this entire time with him. There was no arguing. There was no tumultuous situation happening. There was no wrestling in the car. Look at the photographs in the car. Are there things strewn about that would show that there was some kind of wrestling that he wanted to try to say that was happening in the car? And that's why she got those marks on her neck. Because he doesn't want anybody to think that it could have been from him possibly strangling her. The nonsense. His statement, he says, about the immigrants and that these boats, about these different times he was going to get these boats. Miss Mathewson was clear. Based upon things in their marriage over 16 years, there were reasons for her to believe what he was telling her. Miss Mathewson's vehicle was not a community vehicle. She left him. She moved into that home herself. She bought herself that car and she had a job. That was not his car. That was her car. His car was the minivan that he decided to send his 14-year-old daughter in to drive the 12-year-old and 5-year-old and 7-year-old home. That was his vehicle. She didn't even know what kind of vehicle he had just gotten. There were no marital vehicles at this time. He had his vehicle and she had her vehicle. And she didn't give him permission at any time that weekend to take her car. Everyone reacts to a traumatic event differently. There is no one formula or way that someone should react to a traumatic event right after the incident or 5.5 years later. This is not a situation where Miss Mathewson was kidnapped by a stranger. This was someone who she had been with since she was a teenager. For 16 years, she had been with him. So she knew what she needed to do to try to stay alive in that situation. And that's why she acted the way she did, why she acted to try and befriend him, to keep him calm, to try to not have conflict, because she knew after 16 years, that was the only way, the only chance she was going to ever have to possibly get out of this situation alive. The topic of a Baker Act was brought up during the testimony of the trial, but it's clear from the evidence and Sergeant Steele's testimony is that the defendant was never Baker Acted. He was booked in at the jail on the 14th. There was no 72-hour hold on him. He was in the jail the next day. Another thing to consider when he wants you to think that he is not of the right frame of mind when he is making his confession. But you don't have to just rely upon that confession. We have the written confession from him, and we have the videotaped confessions from him. He wasn't on fentanyl then. He wasn't suffering from a self-inflicted wound then. You have multiple admissions from the defendant. I want to take you through a few inconsistencies in his statements. He had told originally the victim that he had, Miss Mathewson, that he and law enforcement was the purpose of going in there was to say goodbye. He was going to say goodbye. In the middle of the night, he needed to sneak into her home to say goodbye. But then he tells his 14-year-old and 12-year-old that the reason he needs their help to get into the home is to address legal issues, and that he was going to convince Miss Mathewson to come home so they could be a family again. Let's talk about the wrist cutting situation, because Miss Mathewson was clear in her testimony that he cut her wrist because he was mad that she had tried to flee from the Walgreens. And it was done intentionally and purposefully. In his reported statement, he tells law enforcement that he cut her wrist accidentally when he was cutting the rope. Well, let's look at the evidence in the case. We have the back of Miss Mathewson's shirt. The way she wears that is you put your arms through it, it buttons down the front, and where all the blood is in the back. So what does that tell us? What it tells us is that her hands were tied behind her back. She was cut because he was mad that she had tried to flee at the Walgreens. And she bled all over the back of her shirt when her hands were still tied together. He never cut her when he cut the ropes off, because if he cut her when he cut the ropes off, the blood would be on the front of her. The blood would be on the front of her clothes. Miss Mathewson knew she would be hurt if she tried to fight again or she tried to flee again. So she went along with him in order to make sure she didn't get injured. And that's exactly what she told you. The evidence in this case corroborates every witness and every detail Miss Mathewson has told you. He tells you in his recorded statement that he's dead tired, so he had to stop. He had to park and drive in those woods. He was dead tired. If he was dead tired, how can you believe his statement that the two of them slept for hours earlier at her home? They slept for hours together. How did they sleep for hours after they had this consensual sex? and then he'd be dead tired. He was dead tired because he was up for over 24 hours. There was no sleeping after this consensual sex. He was dead tired of having to tie her up multiple times and keep watch on her, trying to get into her phone, find out who she had been talking to. That's what he was dead tired from. If you listen to his recorded statement, he almost makes a slip up and talks about this letter that he discusses that he and Miss Mathewson are going to watch the children from heaven. When he starts talking to the Sergeant Remia about the letters that he wrote, he says, drove all the way into Anna Maria. Right before Anna Maria, there's a boat ramp. We parked, sunlight starting to come up, and she wanted me to write some things. And she said if I did that, she wouldn't tell the police anything. So I wrote out, that she can have the house, car, the money, and whatever I left. Just said and then she wanted me to write, no, she didn't want me to write that. He almost said that he wrote the letter to the kids when he was talking to law enforcement, but he knew he couldn't admit to that because his whole floating over, not discussing the strangulation in that post-Miranda interview would be shot out of the water. He almost confessed to that, but he caught himself because he knew some of his story wouldn't make any sense anymore. He thought he was going to be able to get away with explaining the suffocation of the pillow as a pure accident, a joke. He was just being an ass. But he doesn't even mention the strangulation. He doesn't mention the strangulation because he knew he wasn't going to be able to cover that up once they had found that letter to the children. So he purposefully leaves that out of the statement. It's not a defense. The fact that your estranged wife joins a dating app, it's not a defense to any of these crimes. The fact that she's dating a man that she's not married to, not a defense to the crimes. The fact that she agreed to go with him at one point and changed her mind, not a defense to the crimes. The fact that she has sex with him and is dating other people, not a defense to these crimes. The fact that he wasn't right in the head, needed to go away, not a defense to these crimes. This isn't an insanity case. None of the reasons he gave Sergeant Remia in his confession are defenses to any of these crimes. The state has the burden to prove this case to you beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. What does abiding conviction mean? Abiding meaning firm, conviction meaning belief. If you have a firm belief that the defendant committed these crimes, you must find him guilty of those crimes. He had made the decision that if he couldn't have her, no one would, or no one could. And all of the evidence in this case corroborates each and every single witness that the state has put forth to you. I briefly want to touch upon the aggravation with regards to a weapon when it comes to counts 1 and 2, because the state has charged him with attempted first-degree murder with a weapon. The weapon in count 1 is the pillow. The weapon in count 2 is the rope. The definition for a weapon is 1, any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or 2, any other object that was used, threatened to be used, attempted to be used, or intended to be used to inflict bodily harm. He took that pillow and put it over Miss Mathewson's face, pushed down with all of his weight until she wasn't struggling anymore. He used that pillow in a manner that could be used to inflict bodily harm. Therefore, it was a weapon. The rope. He took it around her neck from behind. The only reason he wasn't successful was because she had her hands tied this way and was able to catch the rope, prevent it from going around the front part of her neck. that rope was used in a way that could have inflicted bodily harm. The state would submit to you, we have proven that the pillow and the rope are considered and are weapons on the March 11th date and on the March 13th date. The facts in this case are almost unbelievable. But with the mountain of evidence that the state has proven to you, has given to you for you to look at and review, tells you exactly what happened and tells you that the facts are not unbelievable, that they are as stated. They are fact, the state would submit to you. The mountain of evidence, the overwhelming evidence in this case points directly to the guilt of Trevor Summers. And we're confident that at the conclusion of this case, you will find him guilty as to each and every count. Thank you.
Gentlemen of the jury, we're going to take a short break. I'm going to give my court reporter at least a little break before I read the instructions to you. There'll also be an opportunity for you to stretch your legs, use the restroom if necessary. It will be a short break. We'll come in and I will read you the final instructions, and then you will return to the jury room to deliberate. Please do not discuss the case amongst yourselves with anyone else. Please do not do any research related to the case. All rise for the jury. Mia, about how much time do you think you need? 5 minutes. All right. Well, we'll take at least 5 minutes. What I want the parties to do is look through now, because you've had some opportunity, but I don't know how much opportunity you've had to flip through the stack that you were provided before closing arguments, which is the changes that we discussed. Before I read to the jury, I'll ask each side to verify that the stack that with the changes is appropriate before I read it. So we'll take a short break. Thank you all. We can take time, but we can take time to do that after I read and they go back. That's usually how we do it. And Mr. Summers will also get the opportunity to take a look at all the evidence before it goes back.
Judge, do you send the whole packet back?
No, I would start with 3.1, the substantive instructions that I'm about to give.
Okay.
Mr. Summers, so when I said I'm going to tell them in the beginning these instructions to go back with them, but it's the instructions that I'm going to read now, not those other things like that one I just read about the attorneys about to give or the parties about to give their closing arguments. It'll be these pages 14 through 58, and I will take the verdict form out. I will explain to them when I get to it that I'm going to remove it from the pack. I'm going to put a paper clip in it, and I'm going to place it on the top of the set of instructions. All right, let's get the jury. Yes, we are.
All right, sir.
Jury is present and seated. Everyone else may be seated this time. Gentlemen of the jury, welcome back. First thing that I want to tell you before I read you the instructions is that these instructions will go back into the jury room with you. So this actual copy that I am reading from will then be sent into the jury room with you, and you will have them available to you during your deliberations. I mentioned that they are lengthy. It's going to be pages 14 through 58 that I'm going to be reading to you. I do apologize for reading to you, but they are written by the Florida Supreme Court. Every word of them is important. I'm going to also go ahead and turn my microphone on at this time so they don't have to scream the whole time that I'm reading them. If at any time for some reason you can't hear me, please just raise your hand and let me know. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions that I am about to give you. Trevor Stephen Summers, the defendant in this case, has been accused of the crimes of attempted murder in the first degree with a weapon, kidnapping, sexual battery by a person 18 or older upon a victim 18 or older, child neglect, grand theft motor vehicle, and violation of domestic violence injunction. Trevor Stephen Summers is accused of attempted murder in the first degree with a weapon in counts 1 and 2. Attempted first degree murder includes the lesser crimes of attempted second degree and attempted manslaughter by act. all of which are forms of attempted homicide and all of which are unlawful. However, let me just go back and read, because I just noticed a typo and I'm just going to correct that by rereading it. Attempted first-degree murder includes the lesser crimes of attempted second-degree murder and attempted manslaughter by act, of which are forms of attempted homicide, and all of which are unlawful. However, an attempted homicide that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find that there was an attempted homicide of Elisa Summers by Trevor Stephen Summers, you will then consider the circumstances surrounding the attempted homicide in deciding whether it was attempted first-degree murder or attempted second-degree murder or attempted manslaughter by act, or whether the attempted homicide was excusable or resulted from the justifiable use of deadly force. An attempted homicide is justifiable and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the attempted homicide. An attempted homicide is excusable and therefore lawful under any one of the three following circumstances. Number one, when the attempted homicide is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or two, when the attempted homicide occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or three, when the attempted homicide is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the attempted killing is not done in a cruel and unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Trevor Summers may be found guilty of attempted first-degree murder. To prove the crime of attempted first-degree murder, premeditated murder, the state must prove the following three elements beyond a reasonable doubt, and this is as to counts 1 and counts 2. Number 1. Trevor Stephen Summers did some act intended to cause the death of Elisa Summers that went beyond just thinking or talking about it. Number 2, Trevor Stephen Summers acted with a premeditated design to kill Elisa Summers. Number 3, the act would have resulted in the death of Elisa Summers except that someone prevented Trevor Summers from killing Elisa Summers or he failed to do so. A premeditated design to kill means that there was a conscious decision to kill. The decision must be present in the mind at the time the act was committed. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the act. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the act was committed. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the attempted killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the attempted killing. An issue in this case is whether Trevor Stephen Summers did not act with a premeditated design to kill, because he acted in the heat of passion based on adequate provocation. In order to find that the defendant did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person, and a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury, and there was not a reasonable amount of time for a reasonable person to cool off, and a reasonable person would not have cooled off before committing the act that constituted the attempt to cause death, and Trevor Stephen Summers was, in fact, so provoked and did not cool off before he committed the act that constituted the attempt to cause the death of Elisa Summers. If you have a reasonable doubt about whether the defendant acted with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, you should not find him guilty of attempted first-degree premeditated murder. If you find that Trevor Stephen Summers committed attempted first-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, or attempted to use a weapon, you should find him guilty of attempted first-degree murder with a weapon. A weapon is defined as 1. Any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or 2. Any other object that was used, threatened to be used, attempted to be used, or intended to be used to inflict bodily harm. If you find that Trevor Stephen Summers committed attempted first-degree murder, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a weapon, then you should find him guilty only of attempted first-degree murder. To prove the crime of kidnapping, this is as to count 3, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Trevor Stephen Summers forcibly, secretly, or by threat confined, abducted, or imprisoned Elisa Summers against her will. Number 2, Trevor Stephen Summers had no lawful authority to do so. Number 3, Trevor Stephen Summers acted with intent to commit or facilitate the commission of grand theft motor vehicle. See definition of grand theft motor vehicle, which is later in the instructions under count 10. In order to be kidnapping, the confinement, abduction, or imprisonment, A, must not be slight, inconsequential, or merely incidental to the grand theft motor vehicle. B, must not be of the kind inherent in the nature of the grand theft motor vehicle. And C, must have some significance independent of the grand theft motor vehicle in that it makes the grand theft motor vehicle substantially easier of commission or substantially lessens the risk of detection. Secretly means the defendant intended to isolate or insulate Elisa Summers from meaningful contact or meaningful communication with the public. This is as to count 4 and 5. To prove the crime of sexual battery, the state must prove the following 4 elements beyond a reasonable doubt. Number 1, Trevor Stephen Summers committed an act upon Elisa Summers in which the sexual organ of Trevor Stephen Summers penetrated or had union with the vagina of Elisa Summers. Number 2, Trevor Stephen Summers' act was committed without the consent of Elisa Summers. Number 3, at the time of the offense, Elisa Summers was 18 years of age or older. Number 4, at the time of the offense, Trevor Stephen Summers was 18 years of age or older. Consent means intelligent, knowing, and voluntary consent and does not include coerced submission. Consent does not mean the failure by the alleged victim to offer physical resistance to the offender. Union means contact. Elisa Summers' lack of chastity is not a defense to the crime charged. To prove the crime of neglect of a child, this is as to count 6. To prove the crime of neglect of a child, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Trevor Stephen Summers willfully or by culpable negligence failed or omitted to provide A.S. with the care, supervision, and services necessary to maintain A.S. physical or mental health. Number 2, Trevor Stephen Summers was a caregiver for A.S. Number 3, A.S. was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in or reasonably could have been expected to result in serious physical or mental injury or a substantial risk of death to a child. Caregiver means a parent, adult, household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. This is as to count 7. To prove the crime of neglect of a child, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Trevor Stephen Summers willfully or by culpable negligence failed or omitted to provide L.S. with the care, supervision, and services necessary to maintain L.S. physical or mental health. Number 2, Trevor Stephen Summers was a caregiver for L.S. Number 3, L.S. was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in or reasonably could have been expected to result in serious physical or mental injury or a substantial risk of death to a child. Caregiver means a parent, adult, household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. I know it's redundant, I apologize, but Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. This is as to count 8. To prove the crime of neglect of a child, the state must prove the following 3 elements beyond a reasonable doubt. Number 1 is Trevor Stephen Summers willfully or by culpable negligence failed or omitted to provide B.S. with the care, supervision, and services to maintain B.S.'s physical or mental health. Number 2, Trevor Stephen Summers was a caregiver for B.S. Number 3, B.S. was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in or reasonably could have been expected to result in serious physical or mental injury or a substantial risk of death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. This is as to count 9. To prove the crime of neglect of a child, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Trevor Stephen Summers willfully or by culpable negligence failed or omitted to provide G.S. with the care, supervision, and services necessary to maintain G.S. physical or mental health. Number 2, Trevor Stephen Summers was a caregiver for G.S. Number 3, G.S. was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in or reasonably could have been expected to result in serious physical or mental injury or a substantial risk of death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. This is as to count 10. To prove the crime of theft, the state must prove the following 2 elements beyond a reasonable doubt. Number 1, Trevor Stephen Summers knowingly and unlawfully obtained or used or endeavored to obtain or use the motor vehicle of Elisa Summers. Number 2, he did so with intent to either temporarily or permanently deprive Elisa Summers of her right to the property or any benefit from it, or appropriate the property of Lisa Summers to his own use or to the use of any person not entitled to it. Motor vehicle means an automobile, motorcycle, truck, trailer, semi-trailer, truck, tractor, and semi-trailer combination, or any other vehicle operated on the roads of this state used to transport persons or property and propelled by power and other than muscular power. But the term does not include traction engines, road rollers, motorized scooters, micro mobility devices, personal delivery devices, mobile carriers, special mobile equipment, vehicles that run only upon a track, bicycles, electric bicycles, swamp buggies, or mopeds. Obtains or uses means any manner of A, taking or exercising control over property, B, making any unauthorized use, disposition, or transfer of property, C, obtaining property by fraud, willful misrepresentation of a future act, or false promise, D, conduct previously known as stealing, larceny, purloining, abstracting, embezzlement, misapplication, misappropriation, conversion, or obtaining property, or obtaining money or property by false pretenses, fraud, deception, or other conduct similar in nature. Endeavor means to attempt or try. It is a defense to the charge of theft if Trevor Stephen Summers had an honest, good faith belief that he had the right to possess the motor vehicle of Elisa Summers. If you have a reasonable doubt about whether Trevor Stephen Summers had an honest, good faith belief, even though unreasonable or mistaken, that he had the right to possess the motor vehicle of Elisa Summers, you should find him not guilty of theft. If you find the state proved beyond a reasonable doubt the defendant did not have an honest good faith belief that he had the right to possess the motor vehicle of Elisa Summers, you should find him guilty if all the other elements of theft have been proven beyond a reasonable doubt. This is as to count 11. To prove the crime of violation of an injunction for protection against domestic violence, the state must prove the following two elements beyond a reasonable doubt. Number one, a temporary or final injunction for protection against domestic violence was issued by a court against Trevor Stephen Summers for the benefit of Elisa Summers. Number two, Trevor Stephen Summers willfully violated the injunction by committing an act of domestic violence. Willfully means knowingly, intentionally, and purposely. Domestic violence means any assault, aggravated assault, battery, aggravated battery, sexual assault, sexual battery, stalking, aggravated stalking, kidnapping, false imprisonment, or any criminal offense resulting in physical injury or death of one family or household member by another family or household member. Family or household members means spouses, former spouses, persons related by blood or marriage, persons who are presently residing together as if a family or who have resided together in the past as if a family, and persons who are parents of a child in common regardless of whether they have been married. With the exception of persons who have a child in common, the family or household members must be currently residing or have in the past resided together in the same single dwelling unit. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proven against beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of attempted first-degree murder are attempted second-degree murder, attempted manslaughter, attempted aggravated battery, and attempted battery. The lesser crime indicated in the definition of kidnapping is false imprisonment. The lesser crime indicated in the definition of sexual battery is battery. The lesser crime indicated in the definition of child neglect is culpable negligence. Next is an instruction that is titled 6.1 Introduction to Attempted Homicide, and then there's a note that says please refer to instruction 6.1, which was previously given and read to you earlier in the stack. Next is to prove the crime. This is the lesser as to counts 1 and 2. To prove the crime of attempted second-degree murder, the state must prove the following two elements beyond a reasonable doubt. Number one, Trevor Stephen Summers intentionally committed an act which would have resulted in the death of Elisa Summers except that someone prevented Trevor Summers from killing Elisa Summers or he failed to do so. Number two, the act was imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that one, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily harm to another, and two, is done with ill will, hatred, spite, or an evil intent, and three, is of such a nature that the act itself indicates an indifference to human life. In order to convict the defendant of attempted second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. An issue in this case is whether Trevor Stephen Summers did not have a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation. In order to find that the defendant did not have a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person, and a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury, and there was not a reasonable amount of time for a reasonable person to cool off, and a reasonable person would not have cooled off before committing the act that would have resulted in death, and Trevor Stephen Summers was, in fact, so provoked and did not cool off before he committed the act that would have resulted in the death of Elisa Summers. If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because he acted in the heat of passion on adequate provocation, you should not find him guilty of attempted second-degree murder. This is also as to lessers counts 1 and 2. If you find that Trevor Stephen Summers committed attempted second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, or attempted to use a weapon, you should find him guilty of attempted second-degree murder with a weapon. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or 2, any other object that was used, threatened to be used, attempted to be used, or intended to be used to inflict bodily harm. I'm sorry, Mia, am I going too fast? No. Thanks. If you find that Trevor Stephen Summers committed attempted second-degree murder, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a weapon, then you should find him guilty only of attempted second-degree murder. To prove, this is lesser as to counts 1 and 2 also. To prove the crime of attempted manslaughter by act, the state must prove the following element beyond a reasonable doubt. Trevor Stephen Summers intentionally committed an act which would have resulted in the death of Elisa Summers, except that someone prevented Trevor Stephen Summers from killing Elisa Summers, or he failed to do so. However, the defendant cannot be guilty of attempted manslaughter by act by committing a merely negligent act. Every person has a duty to act reasonably and to use ordinary care towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. In order to convict of attempted manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act which would have caused death and was not justifiable or excusable attempted homicide, as I have previously instructed you. This is also as to lessers count 1 and 2. If you find that Trevor Stephen Summers committed attempted manslaughter by act, and you also find beyond a reasonable doubt that during the commission of the crime he personally carried, displayed, used, threatened to use, or attempted to use a weapon, you should find him guilty of attempted manslaughter by act with a weapon. A weapon is defined as, number 1, any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or 2, any other object that was used, threatened to be used, attempted to be used, or intended to be used to inflict bodily harm. If you find that Trevor Stephen Summers committed attempted manslaughter by act, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a weapon, then you should find him guilty only of attempted manslaughter by act. This is also as to lesser as to counts 1 and 2. To prove the crime of attempted aggravated battery, the state must prove the following 2 elements beyond a reasonable doubt. Number 1, Trevor Stephen Summers did some act toward committing the crime of aggravated battery that went beyond just thinking or talking about it. Number 2, he would have committed the crime except that someone prevented him from committing the crime of aggravated battery, or he failed. To prove the crime of aggravated battery, the state must prove the following 2 elements beyond a reasonable doubt. The first element is a definition of battery. Number 1, Trevor Stephen Summers actually and intentionally touched or struck Elisa Summers against her will, or intentionally caused bodily harm to Elisa Summers. Number 2, Trevor Stephen Summers is in committing the battery intentionally or knowingly caused great bodily harm or permanent disability to Elisa Summers, or used a deadly weapon. An object not designed to inflict bodily harm may nonetheless be a deadly weapon if it was used or threatened to be used in a manner likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. It is a defense to the crime of attempted aggravated battery if the defendant abandoned his attempt to commit the offense or otherwise prevented its commission under circumstances indicating a complete and voluntary renunciation of his criminal purpose. Renunciation is not complete and voluntary where the defendant failed to complete the crime because of unanticipated difficulties, unexpected resistance, a decision to postpone the crime to another time, or circumstances known by the defendant that increased the probability of being apprehended. If you find the defendant proved by a preponderance of the evidence that he abandoned his attempt to commit the offense or otherwise prevented its commission under circumstances indicating a complete and voluntary renunciation of his criminal purpose, you should find him not guilty of attempted aggravated battery. If the defendant failed to prove by a preponderance of the evidence that he abandoned his attempt to commit the offense or that he otherwise prevented its commission under circumstances indicating a complete and voluntary renunciation of his criminal purpose, you should find him guilty of attempted aggravated battery if all the elements of the charge have been proven beyond a reasonable doubt. This is also lesser as to counts 1 and 2. To prove the crime of attempted battery, the state must prove the following 2 elements beyond a reasonable doubt. Number 1, Trevor Stephen Summers did some act toward committing the crime of battery and went beyond just thinking or talking about it. Number 2, he would have committed the crime except that someone prevented him from committing the crime of battery or he failed. To prove the crime of battery, the state must prove the following element beyond a reasonable doubt. Number 1, Trevor Stephen Summers actually and intentionally touched or struck Elisa Summers against her will or intentionally caused bodily harm to Elisa Summers. To prove the crime of false imprisonment, the state must prove the following. This is the lesser as to count 3. To prove the crime of false imprisonment, the state must prove the following 2 elements beyond a reasonable doubt. Number 1, Trevor Stephen Summers forcibly, secretly, or by threat confined, abducted, imprisoned, or restrained Elisa Summers against her will. Number 2, Trevor Stephen Summers had no lawful authority to do so. Secretly means the defendant intended to isolate or insulate Elisa Summers from meaningful contact or meaningful communication with the public. This is lesser as to count 4 and 5. To prove the crime of battery, the state must prove the following element beyond a reasonable doubt. Number 1, Trevor Stephen Summers actually and intentionally touched or struck Elisa Summers against her will or intentionally caused bodily harm to Elisa Summers. This is lesser as to count 6. To prove the crime of culpable negligence, the state must prove the following 2 elements beyond a reasonable doubt. Number 1, Trevor Stephen Summers exposed A.S. to personal injury. Number 2, he did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consciousness, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such an indifference to the rights of others as is equivalent to an intentional violation of such rights. This is lesser as to count 7. To prove the crime of culpable negligence, the state must prove the following 2 elements beyond a reasonable doubt. Number 1, Trevor Stephen Summers exposed L.S. to personal injury. Number 2, he did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such an indifference to the rights of others, it is equivalent to an intentional violation of such rights. This is lesser as to count 8. To prove the crime of culpable negligence, the state must prove the following 2 elements beyond a reasonable doubt. Number 1, Trevor Stephen Summers exposed B.S. to personal injury. Number 2, he did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such an indifference to the rights of others as is equivalent to an intentional violation of such rights. This is lesser as to count 9. To prove the crime of culpable negligence, the state must prove the following 2 elements beyond a reasonable doubt. Number 1, Trevor Stephen Summers exposed G.S. to personal injury. Number 2, he did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is, of course, a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The defendant has entered a plea of not guilty. This means that you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial, and to it alone, that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1. Did the witness seem to have an opportunity to see and know the things about which the witness testified? Number 2. Did the witness seem to have an accurate memory? Number 3. Was the witness honest and straightforward in answering the questions? It says attorney's questions, but please realize that that also includes the questions of Mr. Summers. Did the witness have some interest in how the case should be decided? That's 4. 5. Does the witness's testimony agree with the other testimony and other evidence in the case? Number 6. Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Number 7. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits that it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You have heard the testimony of a child. No witness is disqualified just because of age. There is no precise age that determines whether a witness may testify. The critical consideration is not the witness's age, but whether the witness understands the difference between what is true and what is not true, and understands the duty to tell the truth. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your excuse me. I apologize. You may rely upon your own conclusions about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to 1, whether when the defendant made the statement, he had been threatened in order to get him to make it, and 2, whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. You have heard testimony of eyewitness identification. In deciding how much weight to give to this testimony, you may consider the various factors mentioned in these instructions concerning credibility of witnesses. In addition to those factors in evaluating eyewitness identification testimony, you may also consider the capacity and opportunity of the eyewitness to observe the offender based upon the length of time for observation and the conditions at the time of observation, including lighting and distance. Whether the identification was the product of the eyewitness's own recollection or was the result of influence or suggestiveness. The circumstances under which the defendant was presented to the eyewitness for identification. Any inconsistent identification made by the eyewitness. Any instance in which the eyewitness did not make an identification when given an opportunity to do so. The witness's familiarity with the subject identified. Lapses of time between the event and the identification. Whether the eyewitness and the offender are of different races or ethnic groups, and whether this may have affected the accuracy of the identification. The totality of circumstances surrounding the eyewitness's identification. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits in evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous, that is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you, and it is as follows. I'm going to hold it up. I don't expect you to be able to read it from there. I'm actually going to read it to you. Also want to let you know that I'm going to take it out of this stack. I'm going to paper clip the verdict. I think it's 3 or 4 pages. And I'm going to place it on the top of the stack. So it's it's 4 pages. So this is it, and I'm going to read it to you. It says State of Florida versus Trevor Summers, and then there's the title verdict form. Under that it says, we the jury find as follows as to count 1. Then there are instructions in parentheses that say check only one letter and answer all associated questions under your lettered selection. Choice A reads, the defendant is guilty of attempted murder in the first degree, and then there's a question. Number 1, did the defendant personally carry, display, use, threaten, or attempt to use a weapon? And then there's choices yes or no. Under that is choice B, which reads, the defendant is guilty of attempted murder in the second degree, a lesser included offense. And then there is the question. Number 1, did the defendant personally carry, display, use, threaten, or attempt to use a weapon? And then choices yes or no. Under that is choice C. The defendant is guilty of attempted manslaughter by act, a lesser included offense. And the question, did the defendant personally carry, display, use, threaten, or attempt to use a weapon? With choices yes or no. Then choice D reads, the defendant is guilty of attempted aggravated battery, a lesser included offense. Then choice E reads, the defendant is guilty of attempted battery, a lesser included offense. Then choice F reads, the defendant is not guilty. On the next page, page 2, at the very top, it says, we the jury find as follows as to count 2. Same instructions in parentheses that read check only one letter and answer all associated questions under your lettered selection. Choice A reads, the defendant is guilty of attempted murder in the first degree. And then the question number 1, did the defendant personally carry, display, use, threaten, or attempt to use a weapon, with choices for yes or no. Under that is choice B that says the defendant is guilty of attempted murder in the second degree, a lesser included offense. And the question, did the defendant personally carry, display, use, threaten, or attempt to use a weapon, with choices for yes and no. Then C, the defendant is guilty of attempted manslaughter by act, a lesser included offense. And the question, did the defendant personally carry, display, use, threaten, or attempt to use a weapon, with choices for yes or no. Then choice D, which reads the defendant is guilty of attempted aggravated battery, a lesser included offense. Then choice E, which reads the defendant is guilty of attempted battery, a lesser included offense. Then choice F, which reads the defendant is not guilty. Under that, it says, we the jury find as follows as to count 3. Then in parentheses, it says check only A, B, or C. Choice A reads the defendant is guilty of kidnapping as charged. Choice B reads the defendant is guilty of false imprisonment, a lesser included offense. Choice C reads the defendant is not guilty. Turning now to the third page at the top, it says, we the jury find as follows as to count 4. Then in parentheses, the instructions, check only one letter and answer all associated questions under your lettered selection. Choice A, B reads, the defendant is guilty of sexual battery by a person 18 or older upon a victim 18 or older as charged. And then under that is question number 1. Did the defendant's sexual organ penetrate the vagina of Elisa Summers, with choices for yes or no. Under that is choice B, which reads, the defendant is guilty of battery, a lesser included offense. And under that is choice C, which reads, the defendant is not guilty. After that, it says, we the jury find as follows as to count 5. Check only one letter and answer all associated questions under your lettered selection. Choice A reads, the defendant is guilty of sexual battery by a person 18 or older upon a victim 18 or older as charged. And under that, there's the question, did the defendant's sexual organ penetrate the vagina of Elisa Summers, with choices for yes or no. Under that, it reads, the defendant is guilty of battery, a lesser included offense. Under that, it reads, the defendant is not guilty. After that, it reads, we the jury find as follows as to count 6. In parentheses, it says check only A, B, or C. After that, choice A reads, the defendant is guilty of child neglect as charged. Choice B reads, the defendant is guilty of culpable negligence, a lesser included offense. Choice C reads, the defendant is not guilty. Under that, it says, we the jury find as follows as to count 7. In parentheses, it says check only A, B, or C. Choice A reads, the defendant is guilty of child neglect as charged. Choice B reads, the defendant is guilty of culpable negligence, a lesser included offense. And choice C reads, the defendant is not guilty. The next and last page of the verdict form at the top reads, we the jury find as follows as to count 8, and then in parentheses it says check only A, B, or C. Choice A reads, the defendant is guilty of child neglect as charged. Choice B reads, the defendant is guilty of culpable negligence, a lesser included offense. Choice C reads, the defendant is not guilty. Under that, it reads, we the jury find as follows as to count 9. In parentheses, it says check only one, A, B, or C. Choice A reads, the defendant is guilty of child neglect as charged. Choice B reads, the defendant is guilty of culpable negligence, a lesser included offense. Choice C reads, the defendant is not guilty. Under that, it reads, we the jury find as follows as to count 10. In parentheses, it reads check only A or B. Choice A reads, the defendant is guilty of grand theft motor vehicle as charged. Choice B reads, the defendant is not guilty. Under that, it reads, we the jury find as follows as to count 11. And then in parentheses, it says check only A or B. Choice A reads, the defendant is guilty of violation of domestic violence injunction as charged. Choice B reads, the defendant is not guilty. Under that, it says, so say we all, dated this blank day of August 2022, and then there are 2 lines, one for the foreperson of the jury to sign the verdict and one for the foreperson of the jury to please print their name. In just a few moments, you will be going you'll be taken to the jury room by the bailiff. The first thing that you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction that I have given in this case, you must tell me by giving a note to the bailiff. Many of you may have cell phone, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys and Mr. Summers before I answer, so it may take some time. If you may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. All right, now, you may have noticed that there are 8 of you. Only 6 of you will be going back to deliberate. We always select alternate jurors. I can tell you that there are many times we have to rely on our alternate jurors. People get sick, emergencies happen, and that is why we select alternates. The alternate's job is just as important as the 6 that are going to be going back momentarily to deliberate. I will have some further instructions for them. At this time, I'm going to ask Mr. Dawson Lefevers and Mr. Anthony Tadone to please remain behind. I will ask the bailiff to take the other 6 jurors into the jury room. I believe there's food back there for you. You can start eating that while you wait for us to bring the instructions, the verdict form, and all of the evidence to you. Again, thank you, and all rise for the jury. Jury has exited. Everyone may be seated. Mr. Lefevers and Mr. Tadone. Am I pronouncing it? Is it Tadone or Tadone? Tadone. Mr. Tadone and Mr. Lefevers, this is the point of the trial when I address the alternates that I never know if they're going to be upset with me that they find out they're alternates and don't get to go back and deliberate. I do want to apologize to you. It just is the manner in which we select, next, and then once we get to 6, the next 2 are alternates. But it has nothing to do with anything you said or anything like that. And as I said before, your job is just as important as anyone else. Many, many, many times we end up having to rely on alternates. Fortunately, this time everyone remained healthy and we did not need the alternates. I am releasing you at this time of all of my prior restrictions about doing research, about talking about the case amongst yourselves or with anyone else. You're welcome to do that. You're welcome to go home now and tell your friends, family members, anyone else who you want to about the case, to talk about the case. You can look up things. As you can see, there's been media coverage. You're welcome to look at any of the media coverage if you wish at this time. We have letters for you that say that you were here all week. They are official letters from the clerk that you can take to work or anyone else who needs to know where you were this week. We ordered lunch for everyone. You placed lunch orders. That lunch is back there. You're welcome to take it with you. I can't let you go in the jury room. If you'd like to stick around and we'll find a place for you where you can eat lunch. If you want to await any potential verdict, you're welcome to do that. Or if you wish to call, we've provided you a phone number. And if you'd like to call later today or next week to find out what the verdict may have been, you're also welcome to do that. At this time, though, I am going to release you and thank you one final time. Thank you, thank you, thank you for your very important service, your attention during this trial, and your patience with us. All rise for the alternate jurors. Alternate jurors have exited. Everyone may be seated. Okay. I'm going to take the verdict form, 4 pages, place a paper clip on it, and it'll be available for you all to take a look at before it goes back. I'm going to take the instructions that I read from, pages 14 through 58, place the verdict form on top, place the entire stack up here. You all are welcome to review the evidence, the instructions, the verdict form before it goes back into the jury room. After that, we will be in recess. The court will be in recess while you do all of that. Computer, for them, or device for them to review the evidence?
We have a couple here, Judge.
Let Mr. Summers take a look at it, review it before it goes back.
Did you make fix the typo for the murder? And then there was a typo on page 58.
Yeah. Let me find. Okay, which was the first typo? No, I couldn't. These are the papers I read from, so I didn't fix any typos.
Did the final version get emailed to your JA or to you?
This was the final version.
I know, but so we could make the change, or did you want to handwrite the word murder in?
I can do that. Is there any objection? Let's go exactly to the instruction that we're talking about, which I read in the correct. Tell me the page number if you know. That's the easiest
It's
way.
on page 16.
Mr. Summers, do you have any objection on page 16? It says,
It's the first line in the second paragraph.
attempted first-degree murder includes the lesser crimes of attempted second degree. It doesn't have murder. It says it subsequently where it says second-degree murder. Do you have any objection to me writing in the word murder after second degree?
No.
All right. And that's what the state is requesting?
That's fine, Judge.
Or it is very possible that... Is she listening?
She is. We've already fixed 6.1.
Okay, they've added murder?
We were fixing that while you were talking.
Okay, we're just going to insert a new one then.
That's the only fix we have, is that?
I don't know. They said there was another one.
Page 58. It said in just a few moments the attorneys will make their closing arguments. I mean, you fixed it when you read it, Judge, but...
Yeah, I said in Mr. Summers. Mr. Summers, do you request any change to that? I read it. It's the standard instruction says the attorneys. This is obviously a unique situation, and when I was reading it, I simply inserted and Mr. Summers. Do you request or for any reason that we make that change on the version that goes back to them?
No, Judge, that's not... Submitting the case is you actually changed it to you will be taken to the jury room. It's supposed to read, in just a few moments, you will be taken to the jury room. We need to take out the attorneys will make their closing arguments because we already did that.
Yeah. No, now I know what you're talking about. You're absolutely right. In just a few moments, the attorneys will be taken to the... Yeah, let's let Christian know that we need to eliminate that line. You see that, Mr. Summers?
I do.
That was... These instructions were like some for when the attorneys do before and some for when they do after. We caught one, but we didn't catch this one. All right. What I'm going to do is, well, that's the very last page, but I'm going to turn them sideways, that one and page 16. So we're reinserting a new page 16 and a new page 58 before it goes back. Will be available for you all to take a look at. They have their, Sergeant, they have their lunch back there. All right, because this might take a few moments for them to get all this stuff, but they're welcome to start. We'll wait for Christina to bring the new 2 pages, and then you can take a look at that. Anything from either side at this time? From the state? From the defense? No, I want to thank both sides for your professionalism, your patience with me throughout the course of the proceedings, and just thank you all very much. Appreciate it. All right. You're welcome. We'll be in recess. If you need me, I'm happy to come back in, but I do want to make sure that Mr. Summers has the opportunity, same opportunity as the state, to take a look at any of this, and both of you give the thumbs up to the bailiffs before they take them back into the jury room.
Yes, sir.
All right. Thank you all. I'll be here. I'll be close by if you need me.
And Judge, the court...
Let the record reflect that everyone is present, including Ms. Johnson, Ms. O'Connor, and Mr. Summers. I have been informed by the bailiffs that the jury has indicated that they have reached a verdict. Is there anything from the state before I have the bailiff bring the jury in?
Nothing from the state, Judge.
Anything from the defense, Mr. Summers, before I bring the jury in?
Nothing, Your Honor.
All right, we'll get the jury. I'll let you all know that I will ask them first who the foreperson is, then I'll ask the foreperson whether they've reached a verdict, and to hand the verdict form, which the foreperson should have, to the bailiff, who will bring it to me. I will review it, make sure that it's signed and dated and that it's completely filled out, and then I will hand it to the clerk to be published. Jury is present and seated. Everyone else may be seated at this time. Gentlemen of the jury, good evening and welcome back. The first question that I have is, was the jury able to select a foreperson? Is that you, Mr. Montclair? I suspected as much by it looks like the verdict is in your hand. Let me ask you this, Mr. Montclair, as the foreperson of this jury. Was this jury able to reach a unanimous verdict on all 11 counts in this case?
Yes, sir.
Do you have the verdict form?
I do.
If you would please present the verdict form to Deputy Estea. Thank you, Mr. Montclair. Thank you, Deputy Estea. I will review the verdict form and then I will present it to the clerk to be published. Today is the 26th, correct? Yes, it is. So, all right, I am going to present the verdict form to Madam Clerk. Mr. Summers, I'll ask that you please stand for the publishing of the verdict.
Thank you.
State of Florida versus Trevor Summers, case number 2017 CF 3896, Trial Division 2. We, the jury, find as follows as to count 1. The defendant is guilty of attempted murder in the first degree, and did the defendant personally carry, display, use, threaten, or attempt to use a weapon? Yes. We, the jury, finds as follows as to count 2. The defendant is guilty of attempted in the first degree, and the defendant personally carry, display, use, threaten, or attempt to use a weapon? Yes. We, the jury, find as follows as to count 3. The defendant is guilty of kidnapping as charged. We, the jury, find as follows as to count 4. The defendant is guilty of sexual battery by a person 18 or older upon the victim 18 or older as charged. Did a defendant sexually organ penetrate the vagina of Alicia Summers? Yes. We, the jury, find as follows as to count 5. The defendant is guilty of sexual battery by a person 18 or older upon the victim 18 or older as charged. And did the defendant's sexual organ penetrate the vagina of Alicia Summers? Yes. We, the jury, find as follows as to count 6. The defendant is guilty of child neglect as charged. We, the jury, find as follows as to count 7. The defendant is guilty of child neglect as charged. We, the jury, find as follows as to count 8. The defendant is guilty of child neglect as charged. We, the jury, find as follows as to count 9. The defendant is guilty of child neglect as charged. We, the jury, find as follows as to count 10. The defendant is guilty of grand theft motor vehicle as charged. We, the jury, find as follows as to count 11. The defendant is guilty of violation of domestic violence injunction as charged. So say we all dated this 26th day of August, 2022. Eric McClare, foreperson of the jury.
Thank you, Madam Clerk. Mr. Summers, you may be seated. Let me ask, does either side wish the court to have the jury polled at this time? State?
Yes, Judge.
All right. Gentlemen of the jury, what that means is the clerk is going to ask each one of you individually whether the verdict that she published is in fact your true and correct verdict in this case.
Jury 1. Juror 1, is this your true and correct verdict?
Yes.
Juror 2, is this your true and correct verdict?
Yes.
Juror 3, is this your true and correct verdict?
Yes, sir.
Juror 4, is this your true and correct verdict?
Yes.
Juror 5, is this your true and correct verdict?
Yes, ma'am.
Juror 6, is this your true and correct verdict?
Yes.
Thank you again, Madam Clerk. Is there anything from either side before the court dismisses this jury? State?
Your Honor.
Mr. Summers?
Nothing from me, Your Honor.
All right,
Thank you.
gentlemen of the jury, this is the last time that I'm going to have an opportunity to thank you for your very important service, your attention here during this trial, and your patience with me and everyone else here. I am at this time able to release you from all of the prior things that I said about not doing any research, not looking up stuff, not talking to others. As you've noticed, there are cameras in the courtroom. I imagine there are media reports about this crime. About this trial. You are welcome now to go and watch those, to look up things, to talk to people. You can tell now your friends, family members, co-workers about the trial. Lastly, your deliberations carry with them a very special protection, and you only have to talk about those deliberations by court order. And that's a rare occasion, but you are able to talk if you decide about your deliberations. That is entirely up to you. So we have letters for you that indicates that you were here all week. I don't know that those letters actually indicate how many hours each day that you were here, but you know now what a tough job it is. And I thank you on behalf of the judges, the parties, the attorneys, the citizens of Hillsborough County for your very important civic duty. With that said, I am going to release you at this time. Please have a safe trip home and an enjoyable weekend. All rise for the jury. Jury has exited. Everyone may be seated. Mr. Summers, the next phase, well, first I'm going to adjudicate you on all 11 counts and revoke any previous bond that may have been posed against you. But the next stage is the sentencing, and you are entitled, again, to representation since it is a different stage of the proceedings, if you so wish. So would you like to be represented by an attorney? That attorney would be your standby attorney, Mr. Marchese, at the sentencing phase of this trial.
Yes, Your Honor, I would.
Okay, so Mr. Marchese, if you'll come on back down, I will.
Excuse me, Judge, I don't have my jacket.
That's all right, that's not a problem. But I will reappoint you from standby counsel to counsel for sentencing. Let me turn to the state now to see. I do not know about Mr. Summers' prior record. Actually, I guess I do. When we went through the colloquy on whether he was going to testify, he had 4 prior, but those were misdemeanors.
4 prior misdemeanors, Judge. He has 6 federal counts that he's awaiting sentencing on up north, but he would be entitled to a PSI.
That was, yeah, that's, I guess, what I was getting to. He certainly can waive that if he wishes. Mr. Marchese, would you like to talk to him at this time about his entitlement to a pre-sentence investigation and whether he wishes to waive such entitlement? Absolutely. Take.
We do not want to waive the pre-sentence investigation. We agree with the state. And I also mentioned some of those felonies are more than 10, some of those misdemeanors are more than 10 years.
Okay, well, the state will ultimately be preparing a score sheet, and I'll ask that they send that to you to take a look at to see if there's any dispute over the score sheet. But in the meantime, we will have the Department of Corrections conducting a pre-sentence investigation and providing us a report. My understanding is that can be done in 2 weeks on an expedited basis, but or longer. So what is the state's request regarding a sentencing date?
Judge, I would leave it open to the court. Can I just check with the victim's family to see if they're not family returning from up north for the sentencing?
Absolutely.
While they're doing that, there would be no need for an expedited pre-sentence investigation. 30 days is what I would think would be normal for one, if we could set a sentencing after that.
Okay. Why don't you come up here with my calendar? Miss Johnson, just while you're over there talking and looking at my calendar, I am the duty judge the week of October 3rd. That would be a great week, any day that week, because I'm not going to be in trial.
Except for Wednesday, because that's a holiday. So
Except for Wednesday, my duty week's a holiday?
Yes, sir.
That's not good news. That means I have to come in on the holiday. But that week of October 3rd is a good week, other than Wednesday.
Mr. Summers has a second case of this.
You're absolutely
You're trying
right.
him on the February case. I can't have him sentenced before the second trial. If he has a second trial, if the state still wishes to go forward with the second trial on this issue of what the Williams rule case was that they brought in, we still got that.
Yeah, no, I appreciate you. I remember seeing that on here, but I don't know that that presents a prohibition. I had somebody recently who had a trial here. I sentenced them. They had another related charge that was separate, and they went back to the division on that. In fact, that would be my intention at this time, to send the other case number, I don't know what the charge is, but back to the division. But that's not going to prevent, unless the state thinks that there's a reason that would prevent us to proceed to sentencing.
No, Judge, he can be sentenced on this case, and then the state can decide what they're going to do on that other case at another time.
Yeah, Mr. Marchese, I mean, I've done it. That's the way we do it.
I'm making objection just because that's the way we used to do it, and
All
the
right.
way I think.
Not a problem. Your objection is perfected for the record.
There
Now,
you
if
go.
you find some authority that you want to submit to me between now and whether that date that we set, and you want to file a motion, I will absolutely review the motion. The state will review the motion. And if you have some authority that says that we should not sentence him prior to that other case being concluded, I will consider it.
Well, just thinking off the top of my head, we sentences them on this one. We get to the next one, they're going to add this one to the score sheet. That wouldn't be right. This is all out of the same incident.
Well, that's an argument that you would make before that court on the score sheet. That would be a score sheet argument that you would make at that. So
I'm still backing up to the argument of why we should have the trial before the sentencing, but
well, technically he's convicted, so I don't know what the ultimate sentence impact would have on the score sheet. He was convicted and adjudicated today, so that would be reflected on his score sheet in that other case, right? The length of the sentence doesn't affect the score on the score sheet for an adjudication. All right. So, week of October 3rd, how's that look for the state?
That works for the state.
Is there a particular day other than Wednesday that's better?
Any day that week, Judge.
Any day that week? Yeah. Mr. Marchese, I see you have your phone in your hand,
Yeah,
so I suspect you're looking at your calendar. How's October 3rd, the Monday?
that's the Monday.
That is the Monday.
Yes, sir.
All right. We'll set that date for sentencing at 9 a.m.
Order PSI to be back by the 28th
I'll
of September.
order a PSI and order it to be back by September 28th. So that'll get it a few days before the October 3rd sentencing. Is there anything else from the state?
Nothing else from the state, Judge.
Anything else from the defense, Mr.
No, Your Honor.
All right. Again, thank you all. Unless I see any motions, if any other motions are filed, post-trial motions, they will be heard on that date at 9 a.m.
Yes, sir.
All right. All right. Thank you all again very much. Have a nice weekend. You're welcome. Madam Clerk, do you have stuff that I need to sign?
He's probably like, wow, that was an experience of a lifetime. He was so enthralled with it. But, wow. I mean, this guy seems like an absolute psycho. Do you see how relieved his ex-wife was? I mean, she was like, oh. Because she probably thought if he got off on this stuff, he'd be out and terrorizing her again. So that was good to see that. But anyways, thank you guys for reaching the goal. I'm going to have to set it higher next time. Man, as soon as you guys hit that... Let's see, what is it? Here, I got to do the thing at the end. Plus, it was 4 hours. I should have made it higher. I forgot. Yeah, we did a 2.5 hour one the other day. Let's see. So thank you to... We'll do the sentencing one tomorrow. I might actually go fishing for part of that with my stepson. I bet we bought some poles and, middle of the day tomorrow maybe. But anyways, thank you for subscribing, Claire and Travis, members, Donna G, Super Chats, K-Me, Cheryl, Danielle, Annabelle, Stealth, Crystal, aka Beaver Gaming, Sub, Crystal, Carla N, Danny ICURN, Mama 457 Rose, Mama She 13, Tina Susser, and Paulette Leonard. All right. So, yeah, I mean, I don't know what the next trial would be, but try to figure out something. But we're going to still do the sentencing. I think there's impact statements and stuff. That might be kind of interesting. So I think we'll do that one tomorrow. All right. But anyways, thank you guys very much, and we'll see you later. All right. And as I always say, be safe out there.
Drama! It's the house! Bitch, please!
Dude!
Mr. Martinez, are you angry at me? 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 Mr. Martinez, are you angry at me?